We're recording.
Good morning and welcome to the Committee on Professional Responsibility and Conduct. As a reminder to our participants, this meeting is being recorded. Under the Bagley-Keene Open Meeting Act, remote members of the committee must be visible on camera unless such appearance would be technologically impracticable. If so, the member shall announce the reasons for their non-appearance during the roll call. Remote members must also disclose any individuals aged 18 years or older that are in the room with them. Karen, can you please take the roll?
Yes. Ali,
Present.
Brown,
Present.
Shivers,
Here.
Coleman,
Here.
Guzman not present. Joyce,
Present.
Matt Watkins,
I believe she is present, but she is trying to unmute.
Sorry, I'm having a little technical difficulty. I'm present.
Mercado,
Present.
Mohebi,
Present.
O'Reilly,
Here.
Perlman,
Here.
Poindexter not here. Riley,
Here.
thank you.
Next on the agenda is the call for public comment. Before we begin public comment, I would once again like to remind everyone that under the Bagley-Keene Open Meeting Act, public comments must pertain to items that are on the agenda or be related to matters that are within the jurisdiction of this agency. Specifically, COPRAC's work includes drafting advisory opinions on issues of professional ethics based on questions submitted to the committee or developed by the committee on its own initiative, drafting fee arbitration advisories, providing guidance to fee arbitrators, administering attorney-client fee agreements, disputes, conducting studies and providing advice to the board on professional responsibility, and studying and recommending changes to the rules of professional conduct. This committee sponsors educational and outreach programs. COPRAC does not have authority over discipline matters. Please note that public comment is an opportunity for members to address COPRAC. During this portion of the meeting, COPRAC members and staff are unable to engage in dialogue or respond directly to commentators. State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool.
For those who are participating by Zoom video, you should have a function for virtually raising your hand. It is a hand icon and should appear at the bottom center of your screen. If you wish to address the committee, please click on the hand icon now, and State Bar staff will call on you in the order the hands are raised. For those who are participating by phone, you may virtually raise your hand by pressing *9. That is a star key, then number 9. We will allow 3 minutes for each speaker. The on-screen will begin as soon as you start your comment, and you will be verbally alerted once you have 30 seconds remaining. I'll go in the order the hands are received. Mr. Kai, you have 3 minutes for public comment.
Good morning. My name is Kai On from Sacramento. I filed campaign against Attorney General Robert Bonta and Sacramento DA Mr. Tian Ho because they did not investigate Sacramento DA office provide fake information. DA case 99F08735. Fake defendant Zhong So Fang killed my father Wen Kang On. However, State Bar closed my campaign without any investigation. Also, Sacramento City Council used a UC Davis internship student to email me a fake police report. I went to UC Davis. I submitted a letter to the Dean of School of Law, but the Dean ignored my reporting. 26 years ago, political power controlled law enforcement, Sacramento law enforcement, to make up a story that my father, Woon Kong-on, was killed by hit and run. Right now, political power is controlling UC Davis Law School and State Bar to cover up the Sacramento DA office, provide fake information. I wonder how this committee can prevent political power to control State Bar to conduct their professional responsibility. If political power can control any policy in State Bar of California, the works of all State Bar committee become no meaning. All members, please inform all California citizens about this incident and stop political power to control California justice and legal system. Chair, Ms. O'Reilly, is it possible that you can add this incident to discuss on the next agenda item?
You have 30 seconds remaining. Thank you for your public.
I'm begging all of you can decide that can make a decision to let me discuss this incident to all the members on the future meeting. Thank you.
Thank you for your public comment. Chair, there are no more other public comments.
Okay, thank you. Next up is the approval of the minutes from our last meeting. Approval of the December 5th, 2025 open session minutes. Are there any corrections or modification to the open session minutes? Okay. Can I have a second? There's a motion to approve in a second, please.
Emil will motion to approve. Oh, sorry.
Emil moves and Eleanor seconds.
Correct.
Karen, can you call the roll, please?
Yes. Ali,
Yes.
Brown,
Yes.
Coleman,
Yes.
Guzman, Joyce,
Yes.
Mad Watkins,
Yes.
Mercado,
Yes.
Mohebi,
Yes.
Perlman,
Yes.
Poindexter, Riley,
Yes.
and O'Reilly.
Yes.
Okay, with 10 yeses, the motion carries.
Okay, thank you. Next on the agenda is my chair's report. I would just like to briefly highlight the priorities for us this year. The 2026 work plan, which we will talk about today. Also civility and AI, which are our primary focuses, and then moving along the opinions that we have in the pipeline, which will come to each of those today. Next up is the staff report, and Rachel Brewer, it's to you.
Thank you. Good morning, everyone. I apologize in advance. My computer screen broke this morning, so I am working off of a new computer that keeps updating and popping things up. So if I seem lost at any point, that's what's going on.
Same for me. Same for me.
So we will be discussing our committee membership today. The applications are open. The deadline to apply is March 31st. So please encourage folks that you know that may be good candidates to apply. We need 2 attorney members and 1 public member. Moving on, UPL is on the agenda for today. However, I just wanted to let everybody know that staff is still working on finalizing a memo to COPRAC, along with our Office of General Counsel. So we'll have that ready for the March meeting, so that we can have a further discussion on it. But there are potential antitrust implications, which is what the memo addresses. As our chair mentioned, the 2026 COPRAC work plan is on the February board of trustees agenda. So we will need to finalize and approve the work plan today. And then one of the other things that I just wanted to highlight, I think we've discussed this a lot, and I know that the internal protocols that COPRAC recently developed seek to remedy some of this. But we did have an issue come up this past month with one of our opinions that has been lingering a little bit longer. Staff discovered that the penal code section that kind of underpins the opinion's entire analysis substantively changed quite a bit in January of this year, and that particular penal code apparently went through 3 different iterations during the course that this opinion was pending. So I just wanted to let everybody know that, to make sure that all of the working groups are keeping up with the rules, regulations, and laws that kind of inform the analysis, because we did have kind of a major change as a result of that. And then just related to that, historically, staff will bring citations into the correct format with the State Bar Style Guide and the California Style Manual. Historically, staff has not done citation checks. So I wanted to bring that issue to the committee to see if all of the working groups and the committee as a whole would like staff to take that on and incorporate that as part of our regular review. We just happened to catch that one this time around, but normally we don't do that. So I'd like to get some feedback from the committee on whether or not that would be helpful to you guys to have staff regularly check those citations and the sites that are in the opinions and the other things that COPRAC is working on. I'm seeing a lot of head nods, yes.
Emil.
Oh, I was just going to respond. Yes, Rachel and I spoke about that offline, and I think I was under the assumption that that was already happening, and that was, I think, my fault. But I think it would be helpful to have an extra set of eyes looking at it from not only style, but also, again, site checking, because things change. When there's 3 or 4 of us working on something, we may move things around and something might get missed. So
I agree with that. I would just say to the working groups, also do that in your own process so that there are double checks instead of just relying on staff to do it, although staff will do it if that works for staff.
That sounds good. Works for me. Okay, so we'll incorporate that moving forward, no problem. And then thank you to everyone on the committee that provided feedback for our civility toolkit. We have finished the revisions based on the feedback from all of the external stakeholders, and that civility toolkit will also be going before the Board of Trustees in February. So thank you so much for the feedback. We were able to incorporate a lot of that, and I am really happy with how the toolkit turned out. So OPC is moving that forward as part of the kind of civility initiatives that the Supreme Court has asked us to work on. We currently do not have anything out for public comment, so I don't have any updates there. And then our next meeting is March 13th via Zoom. And I think that is it for me. I can provide the legislative update when we get to that portion of the agenda.
Okay. Raquel.
Thank you and good morning to everyone. Rachel, can you restate what you said about what the working group should be doing related to changes in rules and other things that affect the opinions? Can you restate what you said we should be doing and what is staff doing in that regard?
Yeah, sure. So it sounds like we we will both be doing the same thing, kind of a check and a double check, making sure that we are checking all of the underlying citations that are referenced in either the ethics opinions or the ethics alerts that COPRAC is working on to ensure that there haven't been any changes to either the statutes underpinning the analysis or any other updates that would impact the analysis.
Okay, so you said that was the second thing you referred to when you said that. Is that the same thing? I was a little, that's why I'm not as clear. You first talked about this penal code changed.
Yes,
So
that
is
was
that-
in
is
one
that
of the
right? So
particular.
that was an example of why you're reinforcing what we should do. Okay, so I
Yes,
just want to
yes.
clarify that. Can
Yeah.
you share the civility toolkit with all of COPRAC so we can be aware what I was on the working group, but I think as a committee, we should be aware of sort of what came out of the committee on for those who were not part of it.
Yeah, we can share that, no problem. It will be in its final approved form after the February Board of Trustees meeting, because they do need to approve it. I don't know if you guys would like to receive it now or after it's been approved by the board or both. Either way is fine with me.
My request is just once it's approved, just so we have eyes on it, right? It came out of COPRAC, so that would be a good idea. Thank you.
No problem.
Okay, thank you, Rachel. The next topic on the agenda is the Ethics Symposium, and we were going to go through each of the proposed topics and hear from the participants or the coordinators of those, the more detail, the more refined scope, the more fleshed out concept, and then a title if you have it. For the leaders, Cassidy, Eleanor, and me, part of what we are waiting to do is figure out what the other folks are covering so that we won't duplicate it. Obviously, there's a lot of overlap in new developments and some of the topics that we're going to be doing. So we'll go after everybody sort of solidifies their thing. So let's start with program 2, Raquel, Novella, and Allison. And what we have from last meeting is ethics in the modern law office, AI, remote work, technology, competence, and supervision. What more insights do you have to share with us today?
Okay. Let me go back to program 1. So was program 1 as identified on the draft topics and descriptions from last month? Was that meant to be the chair's roundtable?
Yeah.
Okay, so, and it just happened to say, primarily it was about immigration and had a couple other things, so it may or may not end up being that.
Yeah, I mean,
Would I hear you? Okay,
for the first
go ahead.
session, I think the idea is that we would try to avoid duplicating. And to the extent that folks are going to be addressing things specifically in the other programs, we won't go into length about it to sort of preempt that. So I expect that we will design program 1 around the other contents. We might cover it or at least talk about it and say it's coming up in program 3 or something like that.
Okay, I would like to just put in a continued plug to in the chair's roundtable. I know I'm on mine, but since we didn't have the opportunity to comment, something about crypto, because that's something that's just been lingering and it's happening in the background, but I think that roundtable, something should be said. I also think the idea of the civility toolkit, I think ended up not being a program. So those were a couple of things that struck me that could be added. Okay, so our working title, and I'm saying working title because we didn't formally submit it because we don't want it to go into stone just yet, is the use of AI a choice, comma, how well-intentioned attorneys get into unethical water. So we are going to focus on AI. We're not going to focus on the other, modern law office, et cetera, et cetera. And so here's the concept. It's going to be an interactive panel. We plan to have a judge, someone from the legal academy, and an attorney, an interactive panel, which will spot common, often utilized legal resources, practices, and tools that may unknowingly raise unethical concerns. We'll be then in the process bringing out emerging case law, consideration, trends, pitfalls, risk mitigations. We're going to figure out how to incorporate the practical guidelines. We have the ones from 23, but there's a subcommittee that's working. So wherever we are on that, because as we've been working on our AI work group, we've got some feedback that in a lot of cases, attorneys kind of don't know a lot about the guidelines and what's really happening. So we should lift those up again. And then as part of the interaction, we may put some polls in there. And so that's kind of our concept. We kind of know we need to finalize what the learning objectives are, X, Y, and Z, but just the learning objective is really the idea that often people say they're not using AI, but now AI is built into many of the tools that they're using. Even Novella mentioned about templates. And so people don't realize that the basic tools they're using, AI is embedded. And so trying to really expose people to beginning to say, even if you're not, by not realizing you are, you are creating ethical issues and challenges for yourself. And let's sort of talk about it in an interactive way. No PowerPoints, just exchange. I see Allison's nodding her head, so I think that if she wants to add something, or Novella, go right ahead. And you're on mute, Allison.
I'm sorry, this is also a new computer for me. We get new computers everywhere. I think you just summed that up really, really well. I have actually nothing to add.
And Novella,
Okay.
questions, comments, adds?
No, I don't have anything to add.
Okay. I like this because I think this is where many lawyers are. You referenced this last time, trying to meet the attorneys that are going to be hearing this and benefiting from this where they are. Attorneys tend not to be early adopters, and so there are people on the forefront of this who are doing things very experimentally, but many lawyers who are in the audience, I suspect, are going to be here, and the tools they use, as Raquel said, already have these things. They think they're not using it, but they actually are, and they need to be aware of the types of things that you'll go through. Okay, so that is refined to be a much more AI centric process, and AI is going to be a theme that comes back a lot, I'm sure, over the next 5 years or more. Okay, and questions for Raquel, Novella, Allison on that topic, that concept? Everybody loves it.
Or not. We're open to suggestions of panelists and/or if you know case law or other things that you think we should take a look at, just send it our way, please. And if you don't reach out to us, if we think you could be of help to us, we'll reach out to you, and please be responsive. Thank you.
Yeah, thank you very much, Raquel. One question is, when you have an academic, is it going to be somebody who is studying it on a sort of conceptual level, or somebody who's talking about its use in like law school?
Yeah, it would be not a theorist, if you will. So somebody who's using it, but also as Allison is a legal, she's in the legal academy. Some of the
Certainly.
things she brought in made us say, oh, we should think about that. So we do have someone who's on our AI working group who may fit the bill just based on he's a legal prof, but he also has a lot of experience. So we haven't decided who that would be, but someone that can bring in a number of things. Less probably about law school itself, but overall.
Okay, that's great. Let's thank you, Raquel, and to your team. Let's go to program number 2. The working description was ethics in the modern law office. No, sorry, that's 2. That's what we just did. We're going to go to 3. Ethical billing and fee management beyond the billable hour. Aaron
Yes,
and Emil.
yes, we met last week and came up with a basic framework, which I literally just sent email because it took me a while to get it out. But basically, I think this will have wide appeal to practitioners to talk about initially what type of fee agreements. I mean, when do you need a fee agreement? And then what type of fee agreements? I think one of the things that the state bar is really ahead of the curve on, and it's been wonderful for practitioners, is providing the different templates for the fee agreements that are available that, thanks to COPRAC from a decade ago, put out, which I think a lot of lawyers still don't even know are there. So we'll talk about that. Then obviously talk about the basic hourly fee agreement, what needs to be there, and then alternate fee agreements, going through fixed fees, standard fees, getting retainers, statutory fees, contingency fees, dealing with cost recovery. And then I think the idea of having a success fee or outcome-based kicker, and when in either a transactional or litigation matter, if that makes sense, and how does all of that, and the tension between, in a contingency case like in a either lemon law or in a employment case, statutory fees versus a contingency, and how that can be dealt with. And then when contingency fees may be abrogated based on like MICRA, which has recently expanded, or the potential Uber legislation that's coming, those kind of issues. I think that's more than an hour.
Yeah.
That would be fine.
And hopefully we can talk
Okay.
about the conversion clause.
I was going to say.
Oh yeah, the conversion clause going in here for quantum Merowit.
What type of panelists do you anticipate?
I mean, I don't think we talked about other panelists at this point, but I mean, I think this is something that I get consulted with constantly, especially in the context of, attorney 1 and attorney 2, both having contingency fees and apportionment issues there. Also problems with, fixed fees, contracts, et cetera, and when if the work wasn't fully completed, those kind of issues. So I think between the two of us, by the next meeting, we can have, if we need to add. I think a panel for an hour, if you have more than 3 speakers, it becomes unwieldy.
Yeah,
So,
the one thing that I thought you could consider is the possibility of having like an in-house panelist or somebody who's on the client side to be able to say, we don't want to do this anymore. And not to bring AI into everything, but you might have a lot more hostility toward a billable hour when AI can do a certain low level of stuff that associates used to do much more efficiently. I wondered about that perspective.
I think that's what we're talking about. Why consider alternates? Well, because that's the way that the industry has to go in order to remain competitive.
The death of the billable hour has been presaged for how long now? I mean,
Well, it
as long
hasn't
as I've
died
been
yet, thank
aware.
God.
Not died yet.
I say my experience is flat fees are usually, they cause their own conflict, don't they?
They can. Yeah.
I don't know. I know some lawyers that have these amazingly high, they seemingly really high flat fees, but then if you're going to go all out to the wall in order to win the case at trial, then you made like $15 an hour.
I was going to say, I feel like the hybrids for flat fees is probably the most realistic. Because,
Yeah, and then exactly, hybrids is something that what we would be talking about
yeah,
as well.
that's great.
Like a truly reduced hourly rate with the potential contingency, which acts as the kicker, I guess, because then you're like really want to put the time in because you're expecting that you're going to get. There's a reason, right? That I think that keeps us in alignment with the client. Otherwise,
Yeah.
a lot of times, especially in like an employment case, when it's statutory fees or 50% on that's because that's what it is now. Then it becomes a potential conflict with the client. to maximize the recovery for the lawyer.
Eleanor.
One thing I'm hearing a lot about lately is how AI is helping lawyers predict with a little bit more certainty the time it'll take to do certain tasks, like perhaps contract reviews and analysis and things like that. And so while that's transactional, I think people are thinking about ways to carve out certain components of cases and put flat fees, onto the e-discovery component or, different types of elements of the case. So that's a hybrid I think we'll see more of. It's just.
Yeah, exactly. And in those, it's more predictable the amount of work necessary. So
Exactly.
to make the flat fee, something that everyone's going to be able to live with.
I think AI will increase that, I guess, in some areas.
So I think this discussion's been really helpful. I think, Dan, you're right that I think an in-house perspective might be great, but audience-wise, are we looking to give the CLE to lawyers that are like solos that work with small clients, or are we looking at folks that work with large clients that have in-house teams? Because, for example, we could talk about outside counsel guidelines, which is another area where fees get impacted. We could talk about capped fees, which is a very common thing in large contracts, and then matter value equivalent, which is something that's very, very common for how a in-house team may value. Like, it's very common in patent prosecution to have that. So if we're looking at our audience, I think we can focus on that more. So I don't know, maybe Rachel, yeah.
Yeah, we can get Rachel's view about the demo graphics for this, but I think it probably skews toward mid and small size firms. But probably the best approach is to not drill too much into something that would be applicable only to one, and to talk more about what Aaron was saying, which is like, where are these fee structures placing the incentives, right? That's my perspective, because if at whatever level you are in, a flat fee for the entire thing up to a jury verdict is going to incentivize a client to hold out.
Yeah.
Right. Versus having different levels where clients feel the pain and may have to take into account the fees that they're paying along the way.
Yeah.
Those types of things, sort of what Aaron was mentioning. And when you have a capped fee, hit the cap, and now it's open season, right? That's my least favorite.
Or sometimes I've seen it's max fees. And so then
Yeah.
you hit that, and now there's a disincentive to continue doing, anything but the most minimal amount of work to keep the file alive.
That's another very good point. Yeah. So on the lawyer's perspective, when those matters hit caps, the incentive is to do less, theoretically. So I think that's an important conversation. But Rachel, so do you have a sense of what our audience demographics are in terms of big, small, solo?
Yeah, I don't have the demographics from the last symposium, but given that it's open to all California licensed attorneys, I think what you said, Dan, about trying to make sure it's applicable kind of across the board and to everyone. And then obviously knowing that when you're talking about larger law firms, they probably have access to more of this information in-house than the solo and small firms. Not to mention that one of the priorities of the board and the bar has been to try and focus on more in California legal deserts and the attorneys that serve those areas, which again tend to be solo and small firms.
Yeah, and I do think that's an important element that you might touch on, is just that a lot of the alternative fee structures can make what might otherwise be very difficult to deliver feasible for the lawyer and the client if it's priced properly. And also, when you're at the very high end of multinational corporations, as a lawyer, you tend not to tell them, they tend to tell you, right? Which we covered last year to some extent. Could we do a quick step back, and maybe for Kathy to chime in as well, about the right mix for everybody of talking, panelists, questions, take questions in real time, take them at the end, chat responses, that kind of stuff for the educational goals we're trying to hit?
I think it's really up to the panel. I think it's really up to the moderators. I would say that typically questions at the end are tough because people speak much longer than they anticipate they will. And so a lot of times they don't get to them. So I think that you should have less material to cover if you want to allow for a lot of those questions. But I really would leave it to the moderator to determine how they want the panels to kind of really look. And I'm more than happy to help if people have questions or kind of, just in terms of timing and stuff. We always kind of want to over stuff and really share a lot of information out. But I think we all know that when we're in presentations, we can't receive all that information. So if we can really hit some really good, impactful points, I think, and the moderator should really kind of be the one steering that along.
Yeah, it's a very important point because almost every CLE that you'll ever attend, 30% of the topics are jammed in the last 3 minutes, and that's not our approach here. I do think that we have the chat. We talked about this a little bit last time, and the staff does real-time responses to that, which is at the early part of the seminar. It's mostly where are the materials, general admin questions that get answered. But I think that it works very well if you can organically take those questions in real time. It's difficult to do when you're presenting, but several of the panels did it last year, and that's what the audience, I think, likes.
Yeah, and I was
Also,
going to say, as Rachel and I are happy to monitor the Q&A, and if the panelist and the moderator's comfortable, we can chime in at the appropriate time and say, this question came up on the topic, if the panelists want to address it, if they're comfortable with that. But if not, we can do some responses, or we can compile the questions to send out responses later as well.
yeah, that's great. I would urge everybody to keep time at the end for questions, but also to be open to taking real-time questions because people want that. Questions for Aaron and Emil?
I have a question. Just clarity. Aaron, it sounded like your thought is you and Emil will be presenting the panel. Is that correct?
I think we can certainly do that, but I think having a third person we need to identify, maybe having an in-house person who like reviews bills, etc., would be a way to do that, or has some facility with different types of fee structures as a
Okay.
client.
Okay, I was just trying to clarify based on the initial question from Dan and then the subsequent back and forth. Thanks.
Thanks.
Okay, other questions on this program 3? Okay, thank you very much. Program 4, the working title is Ethical Billing, Client Funds and Practice Continuity, Fees Accounting and Succession Planning. This is Carrie and Adam.
Isn't that an alternate in case we didn't do the one that Aaron just said? Or no?
There's 4 total sessions, right?
Yes.
So this would be the 4th. The first one is the leadership sort of updates. 2 is you, 3 is Aaron and Emil, and this would be 4.
Which you read as, what did you read it as?
Ethical billing, client funds, and practice continuity.
Adam and I did not have a chance to connect, but we will prioritize that and then report back.
Okay. The general gist of this, though, just for everyone to preview, is that succession planning is a really common question that a lot of people have. There's going to be an epidemic of people who die without any succession plan for their smaller solo practices, just based on demographics of the state and the lawyers. And so I think that to the extent that you can preview these obligations, including our opinion and the materials that the staff has put out on succession planning or is working on, the better it'll be. It's an important point. Anybody have any advice for Carrie and Adam as they refine this on this topic or questions?
I will reach out to you guys, Carrie and Adam, as soon as this stuff is posted to the State Bar website. We are working on the request right now. It's a lot of material, so I'm not sure how long it will take, but I'll reach out to both of you as soon as it's posted so we can coordinate regarding that.
Thank you.
No problem.
Okay, any other comments on the symposium? Time flies when you're in January, and this is coming up pretty quickly. I know it comes together, but we will probably be reaching out to the individual program leaders individually very shortly to start logistics and making sure that everything is on target, primarily also with approaching and obtaining panelists that you may want to participate. Okay.
When can we get the schedule of the timeline of when State Bar is gonna want? So we have typically a calendar that says this is the date, the panelist names we need the title, and this other date, we need the bios. The staff planning to provide that in one document sooner than later versus spilling out over time, one by one. And I guess I'm directing that to Rachel.
Hmm. I'm not familiar with the process for planning the symposium because
Okay.
I stepped in April. I think I mean, if the committee would like staff to set deadlines, we can do that. Or if the committee would like to develop the deadlines now, that's fine too. I mean, we only have one meeting between now and the symposium, and that's March 13th. The next all licensee email, I believe, will be going out early March. So staff can go ahead and get the deadlines together and send it out after this meeting.
Okay, I'll
That would be
send you,
helpful.
Okay.
yeah, I'll send you the one from the schedule from last year. You could look at it. Because it's more related to what staff is doing than to what we're doing. Meaning, because you're building the website, you're communicating with the licensees, like you know when you need what.
Yeah.
We don't really know that.
Okay, no problem. Yeah, we
Okay.
I can pull the one from last year. And I
Okay.
can get one out after this meeting, no problem.
Okay, thanks.
And give yourself extra time because, you know what.
One thing I was going to add about that is that normally, I mean, you can have a fantastic program, but if there isn't enough time to get the word out for it, you're not going to get the people, even on a free event. So really, you need, my experience with LA County Bar or CLA is you need at least 8 weeks of what that means, the solid title, description, speakers, in order to get the marketing out effectively so that people will know the event's happening. So I would say, since it's April 17th, by the middle of February, if that isn't done, then you're making it very difficult for staff to properly market the event. And it's a great member benefit or licensee benefit. So I think we want to get as much word out as possible.
Yeah. I think that timing is right in terms of the starting the messaging and then repeating it as well and having a place for people to go and see it. So we'll build around that.
Okay, and the deadline, or excuse me, registration will open on March 1st. So staff will need to get everything together before then. So we'll go ahead and send out the due dates, but we don't have a lot of time. They are gonna have to be pretty firm deadlines.
Yeah. Okay. Anything else on the symposium? All right. Thank you, everyone. And Carrie and Adam will circle back with you guys on yours. Cassidy, Ethics of In-House Counsel, Business Transactions with Clients.
Okay. I think what we had the last meeting was just some minor revisions that Nima and I were going to do, which we did. And so the first revision, I'll just wait. So Nima added some just sort of practical guidance. If you scroll down, is this go down to the red line? I think this is the red line. Keep going. And so under the 1.8.1 discussion, there it is. So Nima, do you want to just talk about what your thought process was here?
Yeah, of course. Thanks, Cassidy. I think, one of the things that I struggle with in this opinion in general is kind of addressing the realities of in-house counsel situations and putting forth an opinion that could almost be sort of presumptively contrary to what's sort of general practice. And so rather than saying when you have a situation where an in-house counsel gets a compensation plan, that might look like a lot of executive compensation plans, which is common. Just kind of sort of making clear that it doesn't have to follow one form. It requires, the question is, and the inquiry revolves around whether or not the proper disclosures were made. And so I just wanted to sort of make that clear, because I don't want a situation where we put an opinion like this and we have, a bunch of companies that, well, we don't follow this 1, 2, 3, 4, 5-step thing when we issue option grants and the like to our in-house counsel. So just kind of keeping that in there for flexibility purposes.
Yeah, so does anybody have any questions about this addition or thoughts? I like it.
I think it's going to address the issue that you've raised last time and what the Nima just mentioned, which is it could seem like a shock to companies that aren't doing this, but this paragraph illustrates that it can be achieved in multiple different ways depending on the circumstances.
Right. Okay, and then there's no more on that. The other change was under 1.7, if you scroll down. And if you recall, we discussed there's just issues with the discussion about whether or not you can do an advance waiver or when you need a 1.7 waiver, even if you have a 1.8.1 disclosure and consent. When does 1.7 come into play? And there was a discussion about, you could possibly do an advance waiver at the outset if it was sufficiently specific or the circumstances were sufficiently foreseeable, and you can draft the advance waiver with sufficient specificity. But really the issue is, well, what are the circumstances in which a 1.7 waiver may be required? So what I did was I changed it and put the advance waiver in a footnote, because I don't think that's really I don't think an advance waiver is critical here, or necessary. I think it's really just about spotting when 1.7 may come into play. And so I just added this section below, and it basically, I think it just covers that if there is a merger or potential merger and the lawyer is involved, I think that 1.7 comes into play if the in-house counsel is being asked to advise about the merger, advise either the founders or the company itself about the merger and the risks and benefits, and they also have a financial stake in it. So that's when 1.7 would come into play, and would trigger a requirement to get a waiver. So that was the other change I made. And that's it. So does anybody have any questions about that revision or comments? No. Okay, so the other question I have is, does this need to go out for public comment again, or are these substantive changes, non-substantive changes?
So when staff reviewed this, that was one of the things that we looked at, and I think that the two kind of big changes that the working group made were just clarifications or restatements of what was already in the opinion. So I don't view them as substantive, but ultimately it's COPRAC's decision to make that. But if that
was
helps
my
the
thought too.
conversation.
Yeah. Sorry. Thank you. That was my inclination too. So, Eleanor, you have your hand up.
Yeah, I just had a minor nit. So if you want to keep,
Mhm.
are you ready for just a quick nit?
No, go for it.
Okay. In the footnote, I was wondering if the foreseeable, explanation of foreseeable scenarios is the right word, or if it should say risks. I just wondered if scenarios heighten the standard a little bit.
Lawyer may consider in advance conflict by risk. Yeah, I mean I'm just seeing if there's another foreseeable risk. Yeah, I think we can change that to risk. Okay, and I agree. I don't think these are substantive. Do you have another, Eleanor, or anybody else?
Sorry, this is
I
Emil.
I'm in favor of sending it out for comment, but yeah, I appreciate the committee may not agree.
I just saw something in I don't know if it's on this red line, but on the clean version that was in the agenda on page 3, there's a strike through that.
Oh, right. Yeah.
Okay.
Yeah. Sorry. I noticed that too. I think that was in the original, but it wasn't like
It wasn't a red
actual.
line, it was just a strike through, yeah, on page 3.
Yeah, can we make
Right
sure?
there.
I mean, can staff just make sure that it's clean?
Do you want that stricken part removed?
Yeah, because I think we went through, let's see the. No, I can't remember. I do remember thinking like, yes, it should be stricken, but I can't remember why.
It looks like it was a comment from the OC Bar Association that Nima agreed with. I don't know why that's not in track changes, but yes, we can delete that.
So Eleanor, why do you think that it should go out for public comment again? You think it warrants, what is it about the changes that you think are substantive?
Candidly, it's less about the changes and more about inviting further discussion that we didn't get. And maybe these changes will address some of those issues, but I guess I feel like it would be helpful to encourage more comment than we've received from broader group of stakeholders before this goes out in the form of an opinion.
Okay.
I think I would tend to agree. I've heard when I've discussed this with people, I've heard that they don't agree with the conclusion of in-house counsel. They don't agree with this. So with anything, like, I don't know, I don't know of every bill in Congress or every bill at the House. Many lawyers don't know that, we're opining on this. And that's not to say that COPRAC is doing anything incorrect, but it might give an opportunity for more people to comment. Like, for example, if COPRAC is able to get the bar to post this on their LinkedIn profile, it might get some traction to get more comments.
Maybe the Association of Corporate Counsel could be contacted to request that their members review and comment. I just think broader comments appropriate before this one goes out, because it's going to be very controversial, and I want to make sure we're getting the benefit of all the comment we can.
Okay. I mean, it's been out there for a while, and to the extent, it's controversial, there have been comments already.
That's fair.
And the bottom line is, like, if they don't agree with it, then but I mean that's what we struggled with. The rule is the rule, and it's like, we talked about yesterday in the DA meeting, there's not it doesn't seem fair, right? But like that you can't just carve out an exception that doesn't exist. So
I appreciate where you're coming from on that. I guess I'm wondering if there are arguments that we have not considered that could be raised in the comment. It's less about like managing controversy and more about making sure we've considered all the potential arguments that would support the opposition. Like, are there cases that we haven't considered that are analogous that would lead us to take a more, equivocal position?
Raquel, did you have a comment?
This is helpful. I would have said no, don't send it out. So I would be okay to send it out, but we need to send it out through some other distribution channels. I think just sending it out to the same distribution is not going to do what I hear
Right.
people saying, which is we think it's beneficial to have some other eyes on it and get their comment. And so I do agree it's been out a lot to the typical channel. So somebody mentioned social media, but somebody else mentioned somewhere else I couldn't fully hear. So that would be my take. I wouldn't vote to send it out to the same channel, but I would vote to send it out if we're going to broaden who sees it. And then I think it's helpful. Otherwise, I think says we sent it out again, but really not going to probably get much more.
Okay.
I appreciate that. I mean, and again, I think sending it out is fine. I'm not, it's not, this isn't critical to me, but it has been out for a while. I do like the idea of inviting comment from the ACC. And I used to be a member, a long time ago. So does anybody have any connections with anybody over there with the ACC? Eleanor? No?
I don't, but I'm happy to find some. I'm sure
I mean, I can just,
I'm not
yeah,
aware of, but
I still get their emails. So I can just kind of look and see what,
I think the gist would be that staff would send it out in the normal course for public comment, and then the working group members and others that they get in touch with could potentially find some new voices like ACC that would be natural fits to think about this.
yeah.
And publicize that it's out for public comment. Do you want to provide one, please?
Yeah. Okay. Well, can we do like the shorter public comment version or timing, Raquel or Rachel? Sorry.
Yes, we can. We can shorten the public comment period because it's already been out for public comment for 60 days, which is the minimum. I will say this particular opinion has gone out for public comment 3 separate times. And we have received multiple comments every time. So I think if we want to do targeted public comment, that makes sense. It's fine. But I think that we need to make sure we're thinking about that in the first or second round of public comment. Because now we're in a position where we're going to be issuing it for a 4th period. And if substantive changes are made, then we will be issuing it for a 5th public comment period, which obviously delays the process quite a bit. But I understand that, the committee wants to get to the best end result. But it's just something to think of when we are voting things out for public comment in general, if we're trying to get specific feedback.
Yeah, that's a very good point. If there's a sort of a constituency that would be a natural to get a reaction from, it's something that we should be thinking about in the working groups at the beginning of public comment. Emil?
I'll just say maybe I didn't know that it's gone out 3 times. I guess looking at the fact that it's a 2021 opinion, maybe that should have been a hint. So, if the committee has obviously looked at comments that are opposed to this and already made a decision, I think it's just up to us to vote it out. So maybe I'll kind of withdraw my request to push it out again, seeing that it's already gone out 3 times.
Eleanor, what do you think?
I'd like to see it go out and have the working group. I think the shorter period makes sense. I would support that, and paired with targeted outreach to particularly to the Association of Corporate Counsel, because I think I think they're the right folks. I mean, we could ask other people. We could ask academia. Find a few academics that are in this area to see if there's some theory that's being missed here. And that's my primary concern. But I don't know why we haven't heard from ACC.
Okay, Aaron.
Yeah, I was just going to say, I think that this opinion has gotten, a lot of negative feedback. And before we put it out, taking an opportunity to get additional feedback that might be able to help shape it and have more, I think a sense of that it's correct would make it. We shouldn't be afraid of that, and I don't think we should rush it. So I think I'm very in favor of getting it out again.
There's quite a low danger of rushing. That's one fear that we don't have. But yes.
No, but I'm just saying, to say, oh my God, the delay is the reason why we don't want to put it out again. I would say,
Yeah.
no, that is not a basis to avoid, trying to get, because the thing is, if this went out in its current form, right, you're going to get like lots of articles about why this is COPRAC's got it wrong again, type of thing, right? So you may as well have at least got a chance to consider those decisions in advance.
Well, okay. I mean, and again, I agree putting it out to public comment, but it's one thing to say you got it wrong. Tell us why. Like that's the problem, because I started this opinion with the opposite conclusion, thinking 1.8.1 really shouldn't apply to in-house counsel. And then, we couldn't find any substantiation for that position. So, either and we've had this conversation, but either we just don't put it out there and let people just, go on with how they've been doing things and take that risk, which admittingly has been a low risk. Like nobody's been disciplined for violating 1.8.1 as an in-house counsel, as far as I know. Right. But, so maybe that's the solution, but I'm still waiting for someone to say, if you're an in-house counsel and you're given stock in your client, which is your employer, 1.8.1 doesn't apply because X, nobody's told me that, or us, so I think it's either it applies and we put out an opinion, or it applies and we don't put out an opinion and just let the, chips fall where they may. But I don't think there's going to be a position that says that it doesn't apply, but I'm open to, yeah.
Sorry, my concern, Cassie, is we haven't heard the best arguments. Like we haven't heard a well-formed dual hat argument. We haven't heard we just haven't, from my perspective, there are arguments that we have not, I think there may be arguments, let's put it that way, that we have not fully considered. And I know you've been at this and you haven't found anything. And I was part of that, and I agree with you. I saw the shift. I just feel like people with an interest in this might be able to put some other thoughts on the table for consideration. So that's why I'm trying to target it.
I know. I guess I'm not as optimistic as you, but I'm not against it either. So fine. Yeah. Let's just vet it as much as possible, because it is, something that is going to draw, a negative response. So yeah, I no problem with putting out public comment. I'm just, we're going to get the same responses, I think, but maybe not, so.
Somebody like to make a motion to send it out for public comment with the acknowledgement that the working group and others would try to seek targeted constituencies that might provide that.
Also move.
Second? Anybody?
I'll second it.
Aaron, okay.
Yes.
On the motion to send it for public comment.
Let's just the timing,
the time period.
Yeah.
We can do 30 days.
But I don't think there's any reason to if we're putting it out there, trying to get reasoned opinions so that we have the biggest barrels against us.
I agree with that.
Why short circuit to that? That isn't going to serve the point. I think full public comment, no rush at this point. Let's see what they come up with. Hopefully they come up with things that are going to help, make what seemingly it doesn't make sense why it shouldn't be adopted. But let's let people really have a full opportunity to be heard.
Sounds like Aaron's going to submit a public comment.
I was part of the PREC public comment on this. That's why I have background on this.
I'm fine with that.
Believe that LA County Bar does not believe that this makes any sense.
Yes, did they have an alternative?
It makes sense.
I can tell you why. Here, I'll give you the basic thumbnail why. There's a huge difference between a small, startup type of company that is part of your compensation. You're going to be part of the C-suite, blah, blah, blah. That kind of a attorney taking an interest in the startup. Versus you work at Apple because you're one of like 500 or 600 lawyers, then all of those employees at that stratum get whatever the stock option is. It is nothing. It is literally just given to you rather than because you're on like that grade. Those are completely different things.
Right, but where's
the
exception? Where's the exception for that?
Because it's just like as a lawyer, you don't lose rights. Just like as a lawyer, if you're a litigant, you can still talk to the other side. You're not precluded from doing so under Rule 4.2 because you happen to be a lawyer. You have all of the rights as normal folk. So all the normal folk that work for Apple at that sphere, at that stratum, get that. It wasn't a bargain for add-on.
And where's the line? Between, so you've got the really small, like 3 founders and, that where 1.8.1 would totally apply. And then you've got the Apple situation. At what point does it become, it doesn't apply between these two?
When it's just your basic employment contract, which you have nothing to do with negotiating other than maybe the number.
So we're creating an exception that doesn't exist. I
don't think that's a business transaction directly with the client. You're just an employee. And your job happens to be in-house counsel, but you don't have any more or less rights as any other employee. You could be IT. You can just become considered, instead of AI counsel, you could be AI, I don't know, advocate, and all of a sudden not have to do that just because you're a California lawyer, you have less rights. I don't know.
This is a type of theory I think needs to get better developed before it's issued.
That's kind of the discussion I remember having with respect to this, but we'll be happy to put more together, and I think soliciting the opposition to why, because it does sound wrong. Because when things sound so wrong, it's because they are generally.
Saying that is the starting point, but it's actually quite difficult to find that exception. It doesn't exist, and then finding any authority for it also doesn't exist. But okay, we're open to hearing more.
Okay.
Yeah. So we're back to the question of how the length, and I do agree with Aaron. If we're going to make this meaningful, we need to give, the public opportunity to actually look at it closely.
For those who are seeking targeted, sorry to interrupt, but if you're seeking targeted public comment, I think what would be most helpful would be examples of ways that an exception based on the practical anecdotal details that people are bringing up in some ways should be used or could guide this. Does that make sense? The type of thing that Aaron just mentioned, there's a practical difference here. Okay, maybe there could be some analysis, but provide some details about what exceptions might exist for practical and anecdotal scenarios. Has it ever happened before that's created a de facto exception to a rule that isn't in the rule? Things like that.
We've done that before, right? We've done that like when we put it out for public comment, we did like a memo or something asking for specific input. Not on this one though. I think it was on the conversion clause one on whether or not it applies to transactional.
And that went well.
Yeah, I know exactly. We got nothing. But
you see my point. I think the issue is, and I believe the working group is looking at this in good faith each time and hearing these things and saying they feel different. Okay, give us something that we can put in that is more than just like these seem different, right? There might be analogous scenarios where things are treated differently. It might be the employee distinction. Considering the starting point that the working group has already fully reviewed all these details and can't find authority for what people feel is correct. Is that fair, Cassidy?
Yeah, I think I know. I'm just thinking. I'm just.
Eleanor.
I'm thinking. Yeah.
One other thought that I don't know if we've discussed is like, if it feels this wrong, maybe there should be an exception. And maybe that's the proposal is, in certain
A rule change.
circumstances. Yeah. I mean, I just, maybe we invite them to consider that possibility too.
I mean, one thing that we also discussed in these meetings is like, how onerous is this really? Right? I mean, how wrong does it feel just because it's something that nobody does? But
That's fair. Like, are people going to look back and say, well, why didn't we do it? But
And I don't know if anyone considered this idea, but if it already, even within this group, causes enough concern about, I mean, I would imagine it makes most sense to put out opinions that are going to be able to guide conduct of practitioners. And I would hope, and generally, most of the time when that happens, it's not major controversy. So if it's something that we don't expect, and I'll tell you, I have seen cases where 1.8.1 is implicated. And again, it's when the lawyer misuses that role in the startup type of situation and then takes half of the company, blah, blah, blah. Those kind of cases, yeah, that's a 1.8.1 violation for sure, or at least enough to prosecute. There's at least something there. So maybe the answer is putting this kind of a blanket guidance or actually an opinion out there when there's going to be so much blowback because we already know what most people think. I mean, a lot of people think. Then maybe the answer is just don't use pull a bullet in it and kill it, and it shouldn't go out because it's not going to create what the purpose of opinions is, just to provide practical guidance to form and regulate conduct. It's just going to create controversy, which will make, lower the value of a COPRAC opinion in general.
Well, one of the practical purposes of it is to suggest to people that there is not an exception to this.
Right.
You can't find one.
And doesn't it provide that practical guidance to those lawyers who are joining, who are in-house counsel for startups? You know what I mean? Like like those people still need this guidance. I mean, the real issue is whether or not the in-house counsel at Apple has to comply with it. But it's still, I mean, it's guidance. It's guidance for everyone if 1.8.1 applies and it's not an onerous obligation, So I don't know. I mean, if somebody can come up with a justification for an exception for the employee in-house counsel, then I think that would be great. And then we can revise it and it would be we would say there's an exception, that's what I originally wanted to come up with. So.
Okay, I think that sounds good. I think we've more than explained why it needs to be going out for public comment, which I appreciate.
I'm getting that sense. Yes. I feel like our motion to send it for public comment is going to succeed, but that's not to sway your vote.
90 days? Is that what? Yeah. Okay. All right. So do you want to is that what we're voting on? I'm not voting, right?
That's right.
She's not voting.
Eleanor.
Okay, I will move again that this be sent out for public comment for the typical 90-day period.
Anyone second? Aaron.
Okay, I will take vote. Ali?
Yes.
Brown?
No.
Coleman?
Yes.
Guzman? Joyce?
Yes.
Mad Watkins?
Yes.
Mercado?
Yes.
Mohebi?
No.
Perlman?
Yes.
Poindexter? Riley?
Yes.
O'Reilly?
Yes.
8 yeses, 2 noes, the motion carries.
Okay, thank you to the working group and others who provided this insight. Don't be shy about approaching people for targeted public comment and framing the issue that we just sort of worked through. I'm sure the working group will be very happy to receive these details.
Yeah. Should we coordinate on that a little bit now or via email so that we're not stepping on each other's toes there? I'm happy to do some outreach on this one.
Yeah, Eleanor, I mean, yeah, are you on the working group? You're not on the working group, are you?
You know, I was at one point and fell off, and I'm not quite sure how that happened, but maybe I got kicked off.
Bad attitude.
Yeah.
Probably.
I think it's me, Raquel, Nima, and Nima. That's right. Is that right?
I also
I was on it, but I thought I got kicked off too because I hadn't got any notices. So,
Well,
so I was okay. I was like,
yeah,
okay,
no,
fine.
The last assignment was just me and Nima doing
Okay.
the revision. So sorry, I should have
It's okay. No worries. No
But
worries.
so I'm happy. Yeah, I mean, Eleanor and then Dan were on it too at some point. Maybe.
I had Chivers, Brown, Mohebby, O'Reilly. So if that needs to be corrected, please let us know.
Why don't we do Chivers, Brown, Mohebby, and Mercado, and then Eleanor, and then Eleanor and I will spearhead the outreach, and then obviously Nima and Raquel, whatever you can contribute and think of would be great too. I'm sure, Nima, you have clients who have a lot of big companies and who have in-house counsel you can talk to, maybe.
Yeah, I mean, yeah, happy to.
Yeah.
Change. People have to just change. They have to do what they don't want to do. I mean, that's the net of it. If, from my side, I mean, companies don't want to do this, right? And they haven't been doing it because.
Well, they're going to look at this and go like, why, like, I don't care about this. Like, I got to do something, I mean, I know.
No, I know. Yeah.
One way or the other. Okay, that's good. So I'll be in touch with the working group and we'll work on the outreach.
Thank you.
All right, thank you. Next is conversion clauses and contingency fee agreements, and that is Eleanor.
I'm sorry. We moved up the DA ethics alert to the morning to ensure that Cassidy could be here. So
Great,
I believe that was next in our updated agenda.
Okay, thank you. I'm looking at the wrong section of it. Let's go to the the DA seized funds question. Aaron, Carrie, Cassidy, myself. Let's start with Aaron because she drafted it. Then we'll go to Carrie for the counterpoint.
Yeah, I don't think we circulated to the whole group, but just to give a thumbnail to let you know where we're at. I mean, this has obviously caused a lot of gnashing of teeth as well, apparently. Not that surprising. And having considered the health and safety code sections and the only real, I think it's the Carroll case, which talks about the different types of trust accounts, because in fact, there are two types of trust accounts in California. That is correct. It's either an individual trust account denominated for the claimants, and if there's going to be a pooled account held by a lawyer, it has to be an IOLTA. And the health and safety code sections governing asset forfeiture accounts specifically provide for pooled accounts where different claimant funds can be held. And because those funds have to be safeguarded, they actually earn interest while they're being held, having been seized by some kind of criminal authorities, or if it's a civil enforcement case through that process of asset forfeiture. Because they're completely different statutory schemes, this advisory basically would take the position that Rule 1.15 doesn't apply to those accounts, even if they're held by a district attorney's office rather than a county, which is apparently the practice in certain smaller counties in the state. And then the other, and I don't want to actually speak for the other position, but the other position would be that when these accounts are held by the district attorney's office, these pooled accounts that are specifically authorized under the Health and Safety Code section, that if those accounts have to comply with 1.15, then those agencies would have to have individual trust accounts denominated for each of those claimants, as each set of funds is, I guess, seized and then transferred to the district attorney's office from the criminal authorities. And because that's so onerous, we don't believe either way, the answer would be that we don't believe that it should apply. So either if the second alternative is correct and that there isn't an actual, I guess, inconsistency between the Health and Safety Code sections and Rule 1.15, then we would be seeking either a rule change or maybe even more simply some additional language in the client trust account handbook, which would say that Rule 1.15 doesn't apply to seized funds, such as asset forfeiture accounts, which might be the most simple way to resolve the problem if the second course of action is considered. Because on the working group, I think there is a sense that the initial advisory, which would say, oh yeah, all you DA's offices that actually hold these funds in these asset forfeiture accounts authorized by Health and Safety Code, you're going to have to start complying with Rule 1.15. And I think that there's an agreement on the working group that isn't the case, that we don't want to make that type of an advisory, which was the initial suggestion. So that we're still working. How about that? Here's the update. This is still in process. We're not, and we do want to get some guidance from the larger community here, because we have these two different approaches. We have an agreement that this doesn't make sense. The initial suggestion that, hey guys, yes, you've never done this before, there's never been a problem before, but we want you to comply with 1.15 and CTAP, which the rules of procedure regarding CTAP don't even seem to make sense in this case, which these are all points that were raised by multiple district attorney's offices in all those public comments. Maybe the answer instead is to go route one, saying that because the Health and Safety Code section already has a statutory scheme handling asset forfeiture accounts, Rule 1.15 doesn't apply. Or alternatively, if it does apply, then our suggestion is we need a rule change, or at least a change to the client trust account handbook, which will make it very clear that these accounts are not to be regulated through the Division of Attorney Regulation. Those are the two alternatives.
Okay, thanks, Aaron. Carrie, your thoughts?
I think Aaron presented both sides, so I don't know. I need to beat the horse any longer.
Okay. Questions. We've brought this back to the committee because there isn't, and we partly want staff's input on the possibility that it could be resolved with the handbook. I think that the working group is, as Aaron mentioned, has concluded that it doesn't appear to be practical or advisable for this category of funds to be handled under the CTAP rules, even by licensed persons, to the extent they do that. But we haven't been able to resolve it in the working group and want to get the broader committee's opinion about that plus staff. Allison.
We weren't able to distribute the updated draft to the entire committee before today's meeting. It is attached to today's agenda, but I'm not sure if all of the members have had time to review it.
Okay.
And then just regarding the update to the CTA handbook, we are able to make changes to it, but any changes that we make need to be supported by the current state of the law. And I have asked multiple times for citations and the law to back this argument up, and I'm still not seeing it in this most updated draft. So we would need to just make sure that what the law says or the change that we are making is supported by the current state of the law.
Allison.
Actually, Rachel kind of hit on what my question was going to be. So, because it does sound like a simple idea, just put it in the handbook and make it kind of clear. But since we don't have those citations, and I mean, listening to all of the testimony, not testimony, but the different prosecutors who came and spoke at the last couple of meetings, I do think it makes sense that this shouldn't be part of it. But what other options do we have to, maybe I'm confused. What are our options then to go to the State Bar and say, hey, we need a clarification here because there isn't an exception, but it clearly seems to be different.
The answer to that is that we could recommend a rule change. That's one option that would resolve it, and that would become the authority for it. Let me first go to Emil.
So if I recall this, COPRAC was approached by State Bar staff to kind of help put something out there that explains whether or not 1.15 applies to government agencies, specifically district attorney's offices. We have this proposed ethics alert, and we're potentially making more changes. And the issue is that even though there's citations in there to the structure in which DAs hold funds, the issue about creating an interpretation that would be in the CTAP handbook is that there's no authority to say specifically that the trust account rules don't apply in that specific scenario. So we are stuck with just opining. And because it's simply a COPRAC opinion, the bar does not want to put it into the trust account handbook. Am I framing that correctly?
Yes, that's subject to Rachel's comments, but I also would say that it's not even an opinion, it's an alert.
Yeah.
So even potentially, I mean, part of the tension the working group hit, you should guess, you can hear, is that if a court got this as a matter to decide, it would do some type of an analysis of the conflicts, the legislative history, the this, the that, and make a decision. We're not really in a position to do that. We can issue an ethics alert along the lines of what Aaron has written, and there's some schools of thought that suggest that we could fix it with a rule update, but we're not really in a position to adjudicate this issue. And Rachel's correct. There isn't, other than our alert, our view about what it is and what it should be, that it never has happened before. That's not authority. And an alert wouldn't be authority either.
So why not just either we put the alert out or we don't? Like, what's the purpose of and I know we have folks in the audience that have come, and it's been very nice to hear from them. It's been one of the most organized groups that I've seen at COPRAC. But we don't necessarily need to make an opinion just because, or rule change or anything just because it's a hypothetical issue. So there's the possibility that we suggest a rule change, put out an ethics alert, do more research, or do nothing. I think those are like the four options.
Yeah. Carrie, do you want to address the rule change option?
Yeah. So the issue that I take with I agree with the ethics alert as drafted. I believe that it is supported by the law, and I think that it is sound reasoning. I think it reaches an absurd result that does nothing to further the State Bar's stated mission of protecting.
Sorry, you're talking about the original one.
Yes, the original one. The Steve Moad original ethics alert that was created, I believe, is legally correct. I think it is an absurd result that does nothing to further the State Bar's stated mission, right, of protecting the public. And if we send out that ethics alert, DA's offices all over California are going to scramble to comply with it because they are prosecutors who operate with integrity, and they're going to do what our committee says in an ethics alert. So issuing the ethics alert without also concurrently floating up a rule change, I don't think is the correct course at this moment. And so the rule change would take 2 seconds to do. It would simply be adding a comment. And I think that that should be, if we all agree that the language in the ethics alert is correct, but we don't agree with it, then we should just float up the rule change and get that out for public comment and get that process in place.
Aaron.
I think we should probably, or make a decision. We were trying to get like a basic idea, but I think what we should probably do is bring for the March meeting the two different proposals so that people will have actual to see what the citations are in the current advisory, which I think do show that there's no way that an IOLTA account can be maintained by, and no asset forfeiture account could comply with IOLTA and also at the same time comply with the health and safety code sections, because the interest is not to inure to the benefit of the state bar. So it would either be, if 1.15 does comply, does require, it would mean that district attorney's offices that hold these funds would have to individually open up individual trust accounts for each of these times that money is seized. That would be the absurd result, I guess, that we'd be talking about if the initial advisory made sense. But I think instead of talking about it in total, like without seeing the citations, I think it makes sense if we put out both the initial advisory, because it's been so many months now, who can remember with all detail what was said in the first one, what the working group we provided, and then what the potential rule changes, and maybe then we could talk about the different options more in particular. So I think that would be the best approach, because we definitely don't want to put anything out without full vetting. And I think all of us would agree that we don't want to say, oh yeah, all of you guys have to comply with this rule.
No, and we're not, it doesn't help to put something out to say that you don't have to comply with this rule when the state bar itself is saying that's not sufficient authority for us to say that also. Good for you.
Right.
But I think that Carrie captured it, which is the reasoning of the original alert by the state bar is correct. It just hit a result that has not been how people have been doing it, as we've all heard many times from the DAs. And it hit a result that is logical but doesn't seem practical or appropriate, which means maybe a rule change would resolve it. So if we came back next month with a proposed rule change and this other draft and said, now we're going to make a decision, yay or nay, we want to send this rule change out that fixes the problem. Do you want to opine on it in an alert and let everybody get in line to give their opinions? But an alert that doesn't even really provide staff with the type of authority they would need to update the handbook isn't really worthwhile.
And just to be clear, though, I mean, I read the alert that was part of the agenda. It has authority, but it's basically saying we don't believe that DA's offices are covered. But it is I call it an opinion. I know technically it's an alert, but it is the committee's opinion if we vote it out. Well, what's wrong with that? I mean,
the limitation of it is, as Rachel said, that staff has read that and said, this doesn't appear to us to be sufficient authority to change this handbook.
Sure. And as far as we know, the OCTC has not investigated any district attorney's office or county for this conduct. I guess I want to go back to Steve's submission to the group. Was it just sua sponte that we were basically told, hey, take a look at this proposed ethics alert? Or
some very helpful person asked this question from somewhere, right?
Yeah.
I can speak to that. This issue was originally asked to be included in an outline that is currently pending. I forget the exact topic of the outline, but this issue was going to be included in that. And that outline was taking a while to be developed. So staff asked if we could pull this particular piece to draft an ethics alert. So it's not Steve's ethics alert. Staff drafted that. And the original request came directly from the DAs who submitted a request for an ethics opinion several years ago. And so that's how all of this originated. And I just want to highlight why I keep bringing up the citations is because as COPRAC knows, there have been several things that have been put forth on various rule proposals and different changes to the California Supreme Court that they have denied for various reasons. And they, in their orders, they keep referring back to case law. So basically, the legal authority to support what we are doing. And specifically in regards to ethics alerts, it is incredibly important that truly every sentence have the supporting authority. I was recently contacted by the State Bar's Office of General Counsel asking for a citation relating to the judicial threats ethics alert that was issued, because in addition to issuing that ethics alert, we also put forth the proposed changes to 8.2 and 8.4. And so the Supreme Court is currently looking at those, and they were looking at COPRAC's ethics alert, and they were like, hey, you say this in this ethics alert, where's the case law to support that? So this isn't just like a hypothetical concern, it's been a real issue. So I just want to make sure that COPRAC is protected, and everything that we are putting out, if and when it comes under scrutiny, is going to stand up. So that's the reason I'm so concerned about the citations. And it seems to me like we are having a very similar conversation now as we were having with the in-house counsel opinion, where the rule might not make sense and it might produce an absurd result, but where's the authority to say something else? And so that hopefully that gives a little more context for all of COPRAC about why this is such a point of concern.
Let me ask you this, and this is hypothetical, but you can couch your response with caveats. If we did something like Carrie suggested, where we have a revised comment that states it's not intended to include seized funds in law enforcement agencies, does that solve the problem?
I think it would solve the problem, because at that point we probably don't need an alert, and we're just asking for the rule change. And I think there's obviously a lot of history to support that rule request, and we have our discussion and the two different ethics alerts, and I think that would likely solve the issue. And then at that point it is
they'll either do it or
the
don't do it.
recommendation, and they do what they do. Yeah.
Right. Okay, I would be inclined to say that the working group can come back with a proposed revision at our next meeting, and then we can consider it. Everybody will ahead of time review it, and we can decide. We have the benefit of both draft alerts, both the original one and the revised one, with the annotations, and everybody will then be able to make an informed decision about whether they support the revision to the comment. Thoughts on that?
I think that's a good solution to move it forward.
Allison?
I just want to make clear, when you're saying to come back with the revised, will you also be coming back then with a proposed rule change as well to look at the next meeting?
Yeah, a proposed revision to a comment that says this doesn't apply to these constituencies, which we'll work up and propose.
Great.
And just to add to that, obviously, when CTAP was implemented, we did not know that this wasn't going to be an issue until the DAs contacted us, and now we are trying to deal with it. There may very well be other constituencies out there or other circumstances where attorneys are wondering, hey, this do I need to comply? Do I not? So I think that we may want to do a little bit of research and outreach to see if we can cover that so that we aren't back here in a year or two when
Yeah.
a new group pops up and is like, hey, wait, well, what do we do?
If we put the proposed rule change out for public comment, that might achieve that, possibly.
Yeah, but I think it could be broad, like, I don't know, something like other person under this rule is, not meant to encompass government agencies who hold funds pursuant to other state or federal law or something, that seems like a broad enough comment that would apply to a lot of scenarios, not just DA's offices. And I think that's the issue is like, what if the state controller's office suddenly says, hey, we have this issue too? So.
Yeah. And it's true that in practice, as we've all heard from the DAs in the public comments, they all do it differently, somewhat different entities. Okay. The assignment that the working group will take back is to bring a proposed revision to the comments that would reflect that. And then we put up the flagpole and we see what reactions we get. We may learn some things. And then, of course, the powers that be can approve or disapprove it, and everybody then can do what they need to do next. Okay. Any other thoughts on that? Okay, turning from one horse to another that we're going to continue to sort. The next one on the agenda is Emil. Client file release and retention duties.
So this is the one I'm subbing in just for Mary Grace, and it looks like we have to go back to the drawing board. So we're going to need to get the group together to work on that change to the penal code section. So
okay, that's the one from that's changed. Okay,
that's correct.
Got it. Okay.
I think
And sorry, I just had a request from staff. I'm sorry to call you out, Adam. I don't know if you're interested in joining the working group, but given that this deals with the penal code and you are one of our criminal law attorneys, it might be helpful.
Sure, yeah, I'd be happy to do that. I was going to ask what penal code section it was.
I don't remember it off the top of my head. It's one that's dealing with preservation of evidence in felony matters.
Okay.
Which apparently has changed, which is
Yes.
gotta be pretty rare.
Yeah, things don't change a lot in criminal law.
Okay, so
Okay, well,
I did speak to Mary Grace offline, so I'll work with her to get the group going together, and we'll make sure Adam gets to be in part of that. Thank you.
Thanks.
that's good. Thank you, Adam, for also assisting with that. Let's keep it rolling. These are like, they don't make pennies anymore, but this one is coming back. Conversion clauses and contingency fee agreements. Eleanor, hit it.
Yes. Okay. Can staff bring up the red line document for our review? This opinion, yeah, are we calling it the bad penny because it keeps coming back? It's been in the works for years at this point, and the working group has had, there's been several different iterations. From my point of view, the key issue and dispute has been whether the working group or full committee could reach agreement on the issue of whether or not conversion clauses and contingency agreements should be per se unethical as creating an unconscionable fee. And that's how these opinions started out, and they were not, there are people on both sides of this, and we've received a ton of public comment. The argument in favor of the per se approach was really that the lawyer is taking a risk premium and should not be able to transfer that risk back to the client. I think after much debate and discussion and many drafts and public comment, the working group has agreed and reached consensus that there should not be a per se rule, but that there are circumstances where conversion clauses are very likely to be unethical. And that is the needle that we sought to thread with this opinion. in reading it, and I'll just note this, I did see a few nits that I'd like to address, and given the time, I don't think we need to discuss the nits here. I can send a red line with nits, literally just a few word strikes, a word that should not have appeared, that type of thing, to staff after the call or this weekend. But I wanted to just go through the changes. I think everyone's familiar with this, so I don't know how much time we want to spend talking about the structure of the opinion or the arguments that are the positions rather that are laid out. But I'm happy to walk through it if that's helpful.
I think it would be helpful if you could do it in sort of a summary fashion, because not everybody on the committee has seen it as many times as some.
Sure. So the high level, we can just kind of hit it, go to the discussion section, I think, and hit the headings. We did not take the position for any of these headings that it was, I guess we didn't take a position that a conversion clause in any circumstance was per se unethical. But what we did say is conversion clauses that interfere with the client's right to discharge counsel are unethical. And those should be carefully, they should be carefully reviewed for that issue. This section discusses also the timing of a conversion clause and when payment would be due, and if that would affect the client's right to discharge counsel. And I think in the last paragraph, you'll see we said, if the timing of the payment or the clause otherwise makes it such that the client cannot find new counsel, would be left without counsel, or, it's not practical for them to discharge counsel, then it would be unethical or impermissible. The section B deals with the right to control the objectives of the representation. And I think the discussion there centers largely around settlement. And, if there's a conversion clause that impinges on a client's right to settle a case, that would generally be unethical. I guess always be unethical if it's impinging, but we did leave room for the possibility that there could be a circumstance where a contingency agreement with a conversion clause is agreed at the outset. And the circumstances, that underpin that change because the client's objectives change. And, there's an understanding at the outset that if that happens, it'll convert and the lawyer won't accept the risk anymore. And we all agreed that there are circumstances where that would be acceptable. Obviously, it couldn't leave the client without counsel. I think the premise of Section A would still apply. So there are limitations, but we agreed that, it's possible that in some cases that would be ethical, although it deserves heightened scrutiny. Section C is obviously if it creates an unconscionable fee, and that's really the key issue. One could argue, I suppose, that should be at the top, but then it would not be permissible. So here we did a little bit of analysis on timing. If the fees required before the resolution of the case, very likely to be. I think we actually held that was a circumstance where it would be unconscionable. Cassidy, is that right? Let me take another look at this. I'm pretty sure that's one where we came out that would be unconscionable in all circumstances. No, I guess it's likely because we're citing rights of fracassi. But yeah. I don't think we tried to propose an alternative where that wouldn't be unconscionable. I suppose it's hypothetically possible, and the cases just say likely. So that's what we went with. We also cautioned against susceptibility of manipulation by the lawyer. So if it's triggered by the lawyer leaving the case, that would, I think, under the opinion, almost always be unconscionable as well. But there is no strict bright line rule in the opinion. And that's kind of where we landed.
Okay, thoughts or questions about these revisions? The history isn't really as important as the obviously the current draft that's in front of us, but just in brief fashion, there were previously committee members who had the position that if you didn't ban it outright, it was useless. And I don't think that's true. I think there's value in having conversion clauses trigger an evaluation along these lines so that people recognize that in some circumstances, namely these, it could be deeply problematic or a violation.
We went back and forth on whether there was value in an opinion or if it, should be an alert. And I mean, I think many on the committee will remember that debate going back and forth. And I think we leaned toward an alert for quite a while, but there were enough people who thought it might be worth an opinion that we decided to keep the structure.
Yeah, I actually like the way that it came together. I think there's value in this because my sense is that a lot of people who use conversion clauses don't know these lines or they're not thinking of them, and so it has that value.
Yeah, I mean, if there's certain, circumstances present in the relationship, it will, this guidance will allow, red flags to be raised. It'll kind of give pause to those lawyers who would otherwise not have this guidance.
Yep. Okay. Other thoughts or questions about these revisions or the concepts generally? Hearing none, I have a question about the procedural posture of this. This would be going out for public comment?
It is going out for comment, yeah. And like I said, I think I've got a couple little nits, and I don't know if the rest of the working group can do a quick proofread or staff can do that for us as well. I think it needs a close read, but it does need to be voted out, and the changes won't be substantive.
Yeah, I feel like if their typos are small, that it could be done as
Little
part of the
tweaking
ordinary.
matters.
Okay. Is there a motion to what would the public comment period be? This has been out for public comment multiple times before as well.
It has.
Twice at least, I think.
Yes, it looks like it's been out twice. So it's been out for the required 60 days, so it's really up to the committee in terms of how long you would like it to go out.
I'd like to get these things out. It would be nice to get the comment back. I don't expect anything new in the comment. I think we have seen a lot of comments. I wouldn't be opposed to a shorter period if the committee is inclined to do that. I don't expect there's going to be a lot of new comment.
The revisions, though, have addressed a lot of what the substance of them was, which is everybody's doing this, and you're saying it's not possible.
Right. I also don't think we need to rush it, so maybe we just go with the standard period, let people have all the time they need to comment. And
Yeah, that's my thought too. I mean, I don't,
60.
I don't think there's any problems with it. Yeah, we can do 30, 60, or 90. Why don't we just do 60?
Yeah, I think that's good.
sounds
And it's not like it's going to make it on our agenda before like 2 or 3 meetings out anyways at the best. So I think there's no reason to short circuit it.
As revised, it shouldn't be as controversial as some of or black and white decisions of previous versions. So it's also a reflection of the type of revisions we make for public comments and the function of it. A motion to send this out for public comment for 60 days.
I'll make that motion, Emil.
Okay. A second.
Second. Raquel.
Raquel. Thank you.
Alrighty, I'll take vote. Ali,
Yes.
Brown,
Yes.
Coleman,
Yes.
Guzman, Joyce,
Yes.
Mad Watkins,
Yes.
Mercado,
yes.
Mohebi,
Yes.
Perlman,
Yes.
Poindexter, Riley,
Yes.
O'Reilly.
Yes.
With 10 yeses, the motion carries.
Very good. Thank you, Eleanor and Cassidy and the rest of the working group. It's 11:57, and so let's take the lunch break. Come back at 1 p.m.
See you then.
Sounds good.
Or if you want to send your edits on that opinion to me, we can make sure that we incorporate that before it goes out for the public comment.
Thank you, Rachel. I'll do
No
that.
problem.
The meeting is recording, Chair.
Okay, thank you. We'll pick up with our agenda items, and I think next up is Ethics of In-House Counsel, former client's IP, and that is Emil, who may not be on yet.
Yeah, I think he said he was out until 2.
Okay. We'll pass that and come back to it on the agenda. And the next one up is Artificial Intelligence Working Group, and I think Nima is going to take the lead. He's here.
Hey, yes, excuse me. In terms of the general update, I don't know if we talked about this at the last meeting. Rachel, you can correct me if I'm wrong, but since at least since the end of the year, there has been an escalated emphasis on the committee getting through this particular work stream and getting the Supreme Court, an answer to the question posed in October letter sooner than later. Sorry, I'm getting told. So we've had several very, I think, productive committee meetings, and we're moving through the existing guidelines rather quickly, but with a lot of thought and deliberation. We have two outside folks. I think Raquel was referring to one, Dan Rodriguez, who was the former dean of Northwestern Law School. A lot of work in this area, as well as Daza Greenwood, who helped us with the 2023 AI guidelines, who's now rejoined and is quite prominent tech figure in the space, a tech thinking figure in the space. So, I think we're making good progress. Rachel, Jake, and the staff have been doing a fantastic job of kind of keeping us, moving and getting things done that we need to get done. So I think we're gonna be on schedule to get I think, when's our deadline, Rachel?
We will be bringing a kind of final proposed package to COPRAC for the March meeting.
Yeah.
Can I ask what form that will take? Is it updated guidelines? Is it a different thing?
Yeah. So what the form that we thought was best, and again, very open to the thoughts of the product group, if there's other ideas. But the idea is you have the existing guidelines, and because the Supreme Court specifically framed the ask as an update to the guidelines and consideration if there are specific rule changes or comment changes that should be made. What we've done is take the existing guidelines and we're supplementing them as necessary / editing them as necessary, and then separately, in a table kind of format, proposing kind of corresponding changes to the comments or additions to the comments and rules to the extent applicable. A big part of, and then obviously the sort of preamble is now much more updated with like current modern technology, the agentic issue, autonomous issues. And the goal is to sort of craft these in a way that I think, provides some sense of longevity. And so, like these technologies are constantly changing, they're changing quickly. But we're trying to gear the guidelines into a direction and the rules correspondingly into a direction where it doesn't matter what the technology looks like, hopefully in the future. But it's the meetings have been great, and we look forward to continuing the work in earnest. We're meeting once a week at least. So
Oh, good. Thank you for that effort. One question that's just out of curiosity as a preview is that, when we did the first set of guidelines, the technology was not yet at that frontier kind of agentic, meaning that there was a question of a robot practicing UPL, essentially. Now I think we are at that frontier. Do you think that is something that we should address?
So the UPL question is I think a different question, but it's certainly a very relevant question. As you know, I don't think, and I think our committees or subcommittees of the view that UPL is sort of directly within the scope of other than the fact that it, obviously impacts duty of delegation, duty of competence, things like that. But the sort of broader concepts of UPL and how that interacts with an autonomous agent, I think that's probably a little bit beyond what we should get into, just given the direct question from the Supreme Court.
Yeah.
But it is something that, that I think probably the legislature is going to have to wrestle with at some point. And, there's been some states that have, for lack of a better term, sort of taken the leap and allowed more of this type of thing to happen. But, I think probably a lot of it's going to be state by state, but we'll see.
Okay. Great. Any questions for the AI update group? Look forward to getting those details and checking that out next time.
Oh, Raquel, I think Raquel has a hand up.
Oh, Raquel, sorry.
Just would like to request, given the consequential nature of the request and the work that we're doing, that the package go out to the committee earlier than later with, the proposal, and that we have adequate time on the agenda for the committee to interact and engage with it. So I was gonna pull, Rachel, your agenda, because we are working backwards to a request from the trustees, so we're trying to meet their trustee meeting time. So I don't recall post our COPRAC meeting, is there any time built in if the committee gives us something that we'd like to update what we've done?
We would need to schedule a special COPRAC meeting just for that purpose. Because we have our March 13th meeting, and then we have the ethics symposium on April 17th, and then our next meeting after that, I think, is like very beginning of May. And the deadlines for the Board of Trustees are weeks in advance of that meeting. So as of right now, it would have to be the March meeting. If there's anything that the working group needs to take back and reconsider, then we'd need to schedule a special meeting in April to address that. As of right now, under our current schedule, the plan is to get the final package out to all of COPRAC after the working group meeting on March 3rd. Okay. So 10 days before the COPRAC meeting, so everyone can review it in advance.
Okay, and so I wasn't thinking we need another COPRAC meeting. I was thinking we could vote it out, and with the understanding like, oh, these are some of the things we'd add it. So again, why we make sure we have enough time in the COPRAC meeting so we can dispose of it in that meeting. So that was, I wasn't thinking another meeting.
That's a really good point, and we can schedule AI that meeting so it's in the morning. So if any work needs to be done, maybe over the lunch hour, that would give us time, and then we could have the final result by the end of the COPRAC meeting.
Okay.
I think we can also encourage the committee members when they get that packet to review it, to send back comments even before the March 13th meeting.
Yeah.
Just because
absolutely
you can come with a resolution in mind if you have time. Allison.
Great, thank you.
Okay. Anything else on AI? Okay, let's move to civility. And Eleanor, would you please present that topic?
Sure. We just have a quick update for the group, so won't take a lot of time. The committee, or the working group rather, has met and we've discussed the mandate, which is largely to take a look at the case law and disciplinary opinions addressing attorneys' fees reductions for civility issues, and determine or make proposals about codifying the law into the rules of professional conduct. At this point, Adam took on, and thank you, Adam, the initial project, doing the legwork of gathering the opinions. There are a few that we think might be out there that we're still doing a little research on, and staff has kindly agreed to do some additional research to make sure we haven't missed anything that we think is significant in this area, like large awards or large reductions rather, or important cases. Once we have that list finalized, and Rachel, I don't know if you have an update on that or you can give us an ETA, the plan is then to send it to the CCTF and ask the judges group if they've got any recommendations or suggestions. And I think we'll send that along with some comments about which ones we think might be appropriate, get their views, and then take it back and start doing the work of proposing the codification. So that's where we are.
Okay.
Have any questions?
Staff is working on the research right now. I think we'll be able to have it back to you within the week or two. So
That's
pretty quick.
fantastic. Terrific. So I will keep that time frame. I'm going to continue to hold off on sending anything to the CCTF because I'd rather send them a comprehensive list.
And what is the task force doing right now?
That's a good question. We're going to touch base with them after we've got this. I think they're having meetings about strategy. We haven't been invited to a subsequent meeting, so I don't think anything's been put on the calendar, but there was discussion in the last meeting about evaluating arguments to evolve the law in this area. We're not participating in those, at this point. So.
Okay. Questions for Eleanor on civility. We'll look forward to receiving those materials next month.
Sounds good. If anyone's interested, we're happy to share what we've pulled together. If anyone has any ideas on this or cases they think we should look at, please feel free to send them over.
Okay. Did you have
And this is one I just wanted to highlight real quickly, that when we move into the work plan, we're going to have to really nail down specific deadlines and stuff that we are going to put in our work plan for the Board of Trustees, since this is a high profile item. I'm sure after AI, this will be next step on their list of things that they would like to see from us.
Understood. I think that the CCTF will probably turn around its comments pretty quickly. So I think we can have a pretty quick pace on this one.
They've been very responsive. Yeah. They're happy to work with COPRAC. So I think it's a good partnership.
Okay, that sounds like it's progressing apace. Turning to Rachel in a discussion of UPL.
Oh, I'm not sure I actually had anything else to add. I really think that we need the staff memo distributed to COPRAC members in order to have an actual conversation about it.
Is that going to sort of lay out the details about what elements, if any, of UPL COPRAC can or should address?
So it's more addressing the issue of federal antitrust laws and COPRAC being market participants and potentially limiting the participation in the market, aka the people that can practice law. And this is of particular interest to bars that are structured like California, where we are kind of operating as an administrative arm of the Supreme Court. And so it kind of gives an overview of the case law on this particular issue, how other states handle UPL opinions, and will give a suggested kind of special process to follow for UPL opinions to make sure that we aren't running afoul of any antitrust laws. But obviously, given the subject matter, general counsel needs to be involved in that process. So we are working with them on finalizing the memo, but I anticipate it will be done and ready for discussion at the March meeting.
Okay. Yeah, it's a sensitive topic for this committee for multiple reasons. That's one of them. Okay. Discussion and vote regarding new ethics opinions, rules, and other requests. Do we have any ones?
I believe I'm supposed to be presenting on 1.7.
Yeah.
Yes, so we have Riley with 1.7. Chivers, I know hers has to be pushed over since she can't be here. Perlman had People versus Meredith. Mad Watkins had client reviews and solicitation and departing attorney. And we have also received 4 new requests since our last quarterly review. So there are a lot.
Yeah. Okay, let's start with Carrie and 1.7. This is from the January, from the
Yes.
prior meeting.
So we went through this sort of at a high level at the last meeting when I introduced it, but what we were talking about is some California exceptionalism in Rule 1.7, and I can share my screen over here. All right, can everyone see 1.7 on my screen?
Yes.
Great. So this governs conflicts of interest for current clients, and almost every jurisdiction has the same language for subsection A and subsection B, which A talks about basically direct adversity, and then subsection B talks about a material limitation. And that tracks with the ABA Model Rule 1.7, which also has subsection A, which talks about the direct adversity, and then subsection B talking about the significant risk. And then, so that's the material limitation. But then California has this interesting subsection C, which based off of my research, and anyone correct me if you're familiar with the jurisdiction, but we are the only jurisdiction that has subsection C, which basically says that even if there's no direct adversity, and even if there's no material limitation, we're still going to make you disclose when you have relationships with certain parties or people involved in a matter. And it was carried, even when California realigned our rules under the new structure, which I think happened in 2018, we did not realign. This was a carryover from the old rules that is now in the new rules, even though it's not modeled anywhere else in any other jurisdiction. And so when that happened, when they were drafting subsection C, it looks like they used this language here, or responsibility. They added in or responsibility there to sort of track with what's happening up here in B, because you'll see there's the same thing, that it's going to be materially limited by the lawyer's responsibilities or relationships. And so down here, even though there's no significant risk, they still tracked the same language of relationships or responsibilities. And the problem with that is that there are certain responsibilities that you might owe to someone in a matter that you would have to disclose under this section, even though there's no conflict. Even though there's no conflict, and even though there's no significant risk of materially limiting your representation, you still just have to disclose it for disclosure's sake. And that creates some issues when you owe a responsibility or like a duty to say a former client who is now a witness in a matter that you're involved in, for example. You might need to disclose to the other side that you owe a duty of confidentiality to them, even though your representation of them was confidential, for example. So that is the ask from, I think this is from the California, Rachel, correct me, it's the California Ethics who requested.
I'll pull it because I don't remember exactly where this one came from because we have a lot we're working on right now.
Yes. But basically, the idea is that they would just like us to strike or responsibility from C1 because it does nothing to, because again, there's no conflict, there's no material limitation. All you're doing would be disclosing a relationship for the sake of disclosure that would then kind of potentially abut other duties that you owe to a party that you would have to disclose really without furthering any type of public protection mandate. Eleanor, you have your hand up.
My question is, have you given thought to whether that's the only change that should be made, or if a standard should be injected that, requires some at least possibility of it impacting the relationship before disclosure is required?
Given that subsection C only exists in California, it seems like we should probably just do away with the whole thing, but that seems maybe a little bit of a chainsaw that when only a scalpel is required. But it is interesting that we are, even as we tried to move away from some of the California exceptionalism, this persisted, which is interesting.
It seems to me like there should be some sort of a link to an adverse effect on the client before you have to go around disclosing every possible relationship, not just responsibility. That's
and that's the point, right? That's the point of B, is that you have to tell personal things about your relationships or responsibilities because there is a significant risk that there might be a material limitation. And that's an objective standard, by the way. The lawyer can't just say subjectively, like, yeah, the witness is my wife, but there's no way that it's going to materially limit my representation of my client. It's an objective standard, right? And so it's interesting here that there is absolutely no hurdle that has to be cleared. It's just you have to disclose all of your relationships, even when there's no risk to the representation.
And those of others in your firm.
Yes.
Novella.
Which is like, it can get uncomfortable.
Yeah, I think I agree with Eleanor. Like, I felt like Carrie's rationale for striking or responsibility could potentially apply to the rest of the relationships in that subsection, which made me wonder why it was there in the first place.
Yeah, I mean, if the committee thinks that this is important, and I do think that this is important. I don't think that just by virtue of being a lawyer, we need to be held, or even by virtue of being a California lawyer, we need to be held to some different standard than other professionals across the country. But I don't know that asking lawyers to disclose relationships when there is no risk to the representation is a practice that we necessarily need to continue.
There's a standard in one of these, I think, that talks about, like, if the client would think it was important or, likely to affect the relationship. Isn't there a subjective from the client's point of view type of standard in one of the rules?
There might be in other rules, but this one here specifically states that even when there is no significant risk, the lawyers have to disclose it.
Right. I'm wondering if we could borrow a standard from another rule that's, if the client is likely to think, or a reasonable person is likely to think it could have an impact, you must disclose it. Just to make clear it's an objective standard.
But I believe that's this one, the significant
That's
risk.
already, yeah, you're right. I'm sorry. You're right.
Yeah.
So representative clients.
So, and I'm happy to be corrected, but this language does not exist in any other jurisdiction.
I think there might be, let me take a peek around. I think there might be one that's sort of in between these two. If we wanted to keep it, we could look for something like that, although I'd be in favor of striking it.
Yeah, I mean, even like lives with the lawyer, I mean, you have to really disclose a lot of information, even when there's absolutely no risk to the proceedings or the matter.
Does the lives with the lawyer bothers you?
Oh, I mean, just in general, just like to think that like you have to do a written disclosure to the client that like I'm thinking about like, if a criminal defense attorney is married to a cop and they're a public defender and they're married to a police officer who like works at a totally different agency, but then like they have to disclose to all of their clients that they're married to a police officer. It's just kind of wild, So just things that, maybe seem personal even when there's no risk to the representation.
Carrie, would you be in favor of importing like an adverse element test or striking relationship or both?
So I think there's a couple of different levels that we could take to this. I think striking responsibility would at least narrow down the confidentiality concerns that we have. So that would be the most conservative approach. But we could also take on a bigger task of whether or not this should continue to persist, because it's possible that just no one's ever sat down and taken a look at it. And that it's just been adopted, even though the rules have gone through so many iterations, this just seems to persist.
Yeah, to me it is an anomaly because without A or B being present, what is it that you need to disclose? Why, right? Sorry, Novella.
I don't know if I'm just like, I guess I haven't tried to read this carefully before. Like when I'm looking at C2, I guess the other ones expressly connect it to some matter, right? I don't even see that word in C2 or A2, or what's the subsection with the personal relationship?
The whole subsection C is the exceptional section.
Okay.
And that's where basically it's saying, even if B is not true, which is B is the significant risk of material limitation, even if there's no significant risk, we're still going to make you tell people in writing.
Yeah, I also wonder, like, comparing California to other states, like California has a stronger state constitutional privacy right, so then it seems even more odd that the disclosure is broader when there isn't like the threshold in the earlier part of the rule.
My thought is that the rationale for this is that you like sort of what Eleanor was referencing. The client with disclosure, the client can assess whether they think that it's important that your child, for example, is a lawyer at the opposing firm or whatever that may be, whatever the connection may be. But the responsibility to language snags the confidentiality requirements that you'd have with any former client, and means you'd be disclosing all the time if you strictly complied with this.
Yeah.
But I mean, that's a question. If they wanted it to relate to a confidentiality obligation, that could have been specified. It's vague too. I mean, a responsibility to, that could be anything. But I think the intent, Novella, to your question was what Eleanor was alluding to, which is that without disclosure, the client has no way to assess. With disclosure, and disclosure is not considered an onerous requirement typically.
It's a balancing of interest, right? Like, yes, the client has the right to evaluate things that might adversely affect the representation or even the significant risk that it might affect the representation. But I don't know that clients necessarily have an unfettered right to know everything about relationships and responsibilities of their lawyer if it has no bearing on the representation.
Yeah, I think that last part would be the thing. They get to decide that.
But I mean, I think that's, yeah. But I think it's supposed to be an objective, reasonable person standard.
Eleanor.
I think in addition to the privacy, I think there's a lot of just minutia and irrelevant information that would be disclosed under this standard if it was strictly applied. Like, it seems to me like having some sort of a trigger makes sense at a minimum. And that gives you something to at least balance the privacy rights against too. But it's pretty burdensome and I think largely irrelevant if applied strictly.
Yeah, I don't disagree.
I mean, you have a duty to communicate, right? The duty of communication would probably cover most things under this.
Probably would.
And under the duty to communicate, let me look, that's under 2, no, that's 2 point.
That might be where the language is that I was thinking of.
Because that has to do, but that still has to do with like, isn't it like material to the representation?
Yeah, I think you're exactly right. For the duty to communicate to be triggered, it has to be something that's a significant development in that client's matter, not just in general, probably. I mean, although the breakup of a firm, that's going to hit everybody, right? On all, that is going to be significant. Or the leaving of the departure of the, handling attorney. But in general, yeah, I think that the point about a potentially expansive view of responsibility or could include exactly familial or, close friend relationships to be disclosed, which are really not relevant at all to the representation. I would be in favor of the rule change as suggested by Carrie.
So yeah, under A3, it's, reasonably informed about significant developments. And I think that, like, Dan, to your point, you were saying like, well, it's up for the client to decide if it's a significant risk. Like that would cause a lot of these rules to collapse, because then we would say here, like, well, it's actually, it's up to the client to decide whether it's a significant development. So you need to tell the client everything that happens. So there are like Eleanor said, there are certain thresholds to balance the rights of the lawyers and the clients, or the interests at least. Raquel?
I I saw that Rachel said it was the CLA Ethics Committee, and can you just remind us what did they want us specifically to look at? Why did they submit this?
I'm
So
pulling up the request right now. I don't know if you have it on you, Carrie.
So they specifically were taking issue with the language of responsibility here because that could that could conflict with some confidentiality obligations or responsibilities that lawyers have. But then Eleanor made an excellent point that like we don't necessarily have to limit our review of this rule to that one word. Like perhaps there's a bigger issue here that we could address.
Okay, and so after your review, what was your recommendation, Carrie, or had you gotten to that yet on what we should do with this?
My recommendation was that we would strike the responsibility language, but now given this conversation, I think that it could be worthwhile to try and come up with an informed position about why we should modify the whole rule and then put it out for comment and see if this is something that lawyers are even thinking about and grappling with. There might be a lot of California lawyers who don't even know about these disclosure requirements, especially ones who are, licensed in other jurisdictions who don't have these requirements. So it might be better for us to put together like a position and put it out for comment, like we did with the DV rule.
Thank you.
So those are kind of two different things. So maybe the question is whether you would come to March with, I mean, the first one's fairly obvious. You just strike out the language around responsibility too. But would you also come with proposed language importing some type of a standard? And then everybody can decide.
Would anyone be I mean, I don't want to spin my wheels on something if people are like, no, we don't need to take a chainsaw to something that needs a scalpel, but would anyone be interested in considering striking all of it to align with other jurisdictions, or should we keep it simple and strike the thing that is, abutting other duties?
Novella.
I'm interested in striking it. I guess I'm trying to think of what the like other list of relationships do that the duty to communicate wouldn't. So like because that has the threshold built into it, so then it seems like it's just an extra place to say like disclose important things to your client, but it's saying it in like a really broad way.
The duty to communicate, though, relates to their matter.
Yeah. So
where
I guess
these
like
would not.
if I representing someone and then like my roommate appears on the like one of the interrogatory responses for the other side, I would imagine I would disclose that under the duty to communicate because that seems like a significant development. But so I'm wondering like what scenario where something would happen where I wouldn't disclose it under the duty to communicate and I need the other rule to like force me to disclose so the client can assess for themselves if it matters.
Eleanor.
Yeah, I'm in favor of considering striking it too. I think that 1.7B and the duty to communicate probably do the work that needs to be done here.
I'm trying to think of circumstances that would respond to Novella's question, and it's a little hard to do on the fly. I probably can think of it, but I do think there's a set of things that would not relate to a matter and probably wouldn't be in the communication rule that a client would like to know.
Well, just to give you an example, under the current rule, if you're in a law firm of 1,500 lawyers and one of your lawyers in your law firm, like their significant other shows up on the other side, or roommate or whatever, I mean, technically under C1, you have a duty to disclose that.
Right.
But you wouldn't necessarily know, right? Because
It's
you
knowledge.
have,
There's no knowledge. I mean, there's a practical consideration that you don't know, but it
Right.
doesn't say.
It does
Oh,
say it has or
it doesn't-
knows.
Yeah.
I think under
However-
1.10 in the imputation rule, though, I think that C would be carved out
Oh, no.
in 1.110A1, which says the prohibition is based on a personal interest. Because it's talking about being prohibited from representing someone. So I'm not sure if those
No, 1.10 imputation of conflicts, that's based on A or B.
Right. So what I'm saying is would an attorney who's in a law firm that has this personal relationship that requires disclosure, is that imputed to the entire firm or not?
No,
I don't think it is.
No, that imputation is about disqualifying conflicts when an attorney is personally disqualified from representing a party under A or B. 110 addresses whether their personal disqualification is imputed to the rest of the firm, but C is a disclosure requirement that applies to everyone regardless. The only limitation here, as Dan or someone just pointed out, is that you have to know about the relationship. But this isn't a 110 disqualification issue. This is just a disclosure client knowledge issue.
I must have misheard them because I thought that I heard somebody say that this was like an imputed situation to an entire firm, but it sounds like that was not what was said.
I think what we were talking about here is under C1, it's either the lawyer has the relationship that needs to be disclosed, or the lawyer knows that another lawyer in their firm has.
Oh, got it. Okay. Got it.
That's the imputation right there. It's not a 110 imputation.
Okay. Thank you for clarifying that.
But I mean, it's on the road to this imputation concept, which is basically, it's between the conflicts of A, B, and imputation, where you can imagine a scenario where a client might want to know that the partner in the office next to you at your firm has a spouse, for example, who's got these connections to a party or a witness, and then they can determine that's a problem or that's not a problem. But it's pretty broad.
Yeah. I mean, again, like I think of in the criminal context, I think about there are a lot of DAs and there's a lot of DAs and public defenders that are married to each other. There's a lot of lawyers on both sides that are married to law enforcement officers. And so but like that officer is a witness in your case, and you know that your colleague down the hall is married to them, it's going to have no effect on your representation, but you're still going to have to tell your client that something like really personal about another lawyer,
Yeah, I think that's a scenario exactly that this provision is designed to address. And I'm thinking that because this has come up in different times, and exactly this, we've concluded that it basically means that the drafters made the decision that the client should know it and decide whether they think it's important or not, or significant or whatever.
But like many of our other rules, we have throttles, and
Yeah.
we don't just give clients unfettered access to information to allow them to decide what's important, what's not. We have hurdles that have to be cleared.
Yeah.
And this one just doesn't.
So the initial question is whether a revision would be limited to the responsibility language, which I think would should be cleaned up in any event because it's so broad and vague. Second question is whether there should be some type of the standard brought into both subsections of C so that you don't have to just disclose things that you don't think would ever make a difference. And then the third one, I guess, would be just strike C completely because the model rules don't have a C.
The model rule, and again, as far as I can tell, no other jurisdictions.
Eleanor.
If we go down the road of striking it, we could consider comments that would kind of, I guess,
Maybe
explain what
eliminate this.
might be material.
Yeah.
Yeah, and we could absolutely point to under B, we could say, even when there's no significant risk, you should consider your duties to communicate material developments, and we can pull that language from those other sections and put it in a comment.
The 2018 rules have all kinds of basically legislative history for the rules. Is there anything in there that suggests why they might have kept this or made it different? I mean, it's something to look at if you haven't seen that yet.
Back when I reviewed this the first time, I understand that well, I was really focused on responsibility at the time. Responsibility 2 passed by a narrow vote of like 9-8. And it was really just to align it with subsection B without really thinking about the implications or those duties that might be owed. So, but I can go and look more broadly at the legislative history and see why this has persisted.
Sometimes there's something in there that might be interesting. Sometimes they just don't even address it. They just pull it over and it's just there. And it might be just generally that the mandate was conform these to the model rules with the least changes possible. Some fewest changes possible, something like that. I don't know.
But this is like the most changes possible, right? This is like, this is just such a unique section altogether.
At a minimum, the responsibility to language is super broad and would be basically anything. I mean, you have responsibilities of all sorts to all kinds of people.
Yeah.
So, okay, well, what if you would come back to the March meeting with 3 versions? One take fixing the responsibility question, the other one importing some kind of a trigger along the lines of what Eleanor and Novella have been talking about. And then the third way is crossing out C. And we'll take a look. Because Eleanor's correct. If we put that out for public comment, we'll get public comment on why this is critically necessary, right? Allison.
Hey, just looking like really quickly, if you're looking at the rules on page 7 going all the way down because they have the comment period, like what was discussed, they put in that opening paragraph to say in response to the first round of public comments on it to try to make it clear why they were adding it. And they kept it from the old rules. It was, I guess, it looked like it was B1 in the old rules. So they moved it in, but it was intentional to keep it. It wasn't just a mistake. Like they brought it over, didn't think about it.
Yeah, and that seems to me like, because previous to the model rule update in 2018, the old rules had this as one of the conflict provisions, right?
Yeah.
And then when you bring in the model rules, which has A and B, you don't really need this, really, but it does have a different function. So, okay. They did it on purpose. It doesn't mean it was good or correct. Yeah.
Right. It doesn't mean it's not worthy of scrutiny. Also, sometimes it's just easier to say we will just, we'll bring it over. But I at least thought a lot of the work that was done in 2018 was to try and move away from California exceptionalism with a lot of our rules.
Whatever gave you that idea? That was the whole exercise, but there's a lot of resistance to that in California, it turns out.
Well, maybe we all value our privacy a little bit more in 2026, and so it's worth taking a look.
Yeah, I think it's an interesting point that as written, it means you're disclosing relationships that you think have no impact and that are personal and private.
That objectively have no impact, but we're going to tell you anyway.
Right, because the client may subjectively think that it does. Yeah.
Anyone
But
else
you
think
know the old adage, the client is always right.
Yeah. No, this is baseball, right? My brother's cousin's roommate from, yeah.
Mm-hmm.
Okay, so you propose to come to the next meeting with some red lines?
Sure. Is anyone interested? I mean, so are we forming a working group for this, or is this just?
Well, let's say, yeah. Well, how do we form working groups, Rachel? Do we have to vote on that, or can we just do it?
No, the committee can just do it, but if this is going to be something that the committee is taking up and adding to the work plan and working on this year, then we would need a formal vote in order to get that process started.
We would entertain a motion to create a working group related to the revisions, assessing potential revisions to 1.7C.
I will move to create a working group to evaluate and discuss potential changes to Rule 1.7C.
I will second.
Okay,
I will just say if it is a formal working group that is motioned and seconded and voted on, then it is subject to Bagley-Keene. If it is an informal working group, the way that we have done all the other working groups, then we are not subject to Bagley-Keene. So I would suggest forming a working group just informally, the way that we normally do. So
that was my question. How do we normally do? How do these come about?
Yeah, I mean, if we want to form a working group to kind of put forth the proposals, and then at the next meeting, the full committee can vote on whether or not to move forward with any of these and take them up, I think that would probably make the most sense.
Let's do that.
Okay.
Without objection, we'll make an informal working group to assess these 3 potential red line revisions. Does anybody else want to be involved in that informal working group? Eleanor, Novella?
Sure.
Yeah.
Should be interesting. Okay.
The group's back together. The reworking rule group is back together.
You get your red pen out, then you want to use it on something.
There you go.
The charge again.
Yeah. Cool. Thanks.
Okay, so Cassidy did send us an update by email on hers, and it was that she'll be able to present the detailed outline in the March meeting.
And what was Cassidy's, Dan?
Sorry, I just lost it.
If she sent it to us in our emails, I'll look at it. It's okay.
No, she just emailed it to me.
To you.
Just in case we were wondering, but now I'm trying to find it.
It was when lawyers make mistakes.
Yeah.
Okay, thanks.
Okay, while I'm still trying to find that, somebody who has that in front of them, let's go to the next one. And again, these were the ones that we took off the list from a long time ago, and we went through at the last meeting and determined that these would be followed up on, and we're now hearing the follow-up. So what's next on that, Rachel? Can you tell me?
Adam and People v. Meredith. Disclosures regarding obtained defense evidence.
Yes, I don't know what just happened to my video. Sorry about that. Okay, so People v. Meredith has to do with a murder and robbery case where these 2 guys robbed and then murdered the victim, and one of the defendants, Meredith, tried to burn the victim's wallet, and he wasn't successful and just threw it in his trash outside of his house like the genius he was. And then once he was represented in court, he told his attorney where the wallet was. His attorney sent an investigator to the client's house. The client was in custody. And that investigator retrieved the wallet and then subsequently turned it over to the police. And so the prosecution wanted to question the attorney. And there was a lot of litigation, but the judge ended up forcing the attorney basically to violate, or what he thought was a violation of his attorney-client privilege. The decision was very specific, and so this is the holding in the case, I think, is pretty narrow and just covers a very small point of law. But what the court said was that if an attorney learns about evidence in a criminal case, or in any case, I guess it would apply, and manipulates it, then there's no more attorney-client privilege. However, if the attorney's investigator or the attorney had gone out and looked and saw, yes, the wallet is in the trash can, without manipulating it, meaning without touching it, there would, the attorney-client privilege would be intact and wouldn't be violated. And the court was very specific about that, saying that if the attorney's investigator hadn't touched it, we couldn't have forced the attorney to disclose where he got that information. The attorney ended up being a witness for the prosecution at the trial. He was obviously represented by another attorney by the time the trial rolled around. So, again, it's a very narrow factual scenario. I mean, I've been a criminal. I was a prosecutor for over 10 years. I've been a defense attorney for over 20 years now, and I've never run into this problem. Not once, not when I was a prosecutor, not when I was since I've been a defense attorney. So I don't know if anyone has any questions. I don't know.
Because your clients competently burn the wallet, is that what you're saying?
Yes, if you have clients, make sure they know how to destroy evidence properly.
Sorry. What would the request to COPRAC be? There's a case and there's a precedent and it's a rare instance. So what would the request to us be?
I don't know. I was just asked to look into the issue. I don't know if Karen knows the answer.
Yeah, Karen and I were just discussing that, and that's why I'm laughing, because we do not have a formal request. This was noted as something that COPRAC brought up on its own back in sometime before 2022. So not sure we have anyone left who might remember what that was about.
Okay. Well, based on Adam's experience in criminal law, that it's quite rare and that there is a case that is already precedential value on that issue, I think we should move on.
I agree.
Okay. Thank you, Adam.
And sorry about my camera. I think it decided to crap out right at the most inappropriate time.
I assume you're burning a wallet right now, is what I assume. You don't want to see it.
It's out in my backyard.
Okay. All right. I do have the list back. Thanks, Adam. And next up is Allison on client reviews and soliciting them and the ethical limits of that.
Okay. Can I share my screen?
As long as you are sharing like something like the rules that Carrie was sharing, that's fine. If it's something that you developed for this, then we can't share it until it's posted online.
Okay, so then I'm not going to share anything. All right, let's talk about it. So the okay, this is the favorable rules 102 or 113? I was looking at 2.
Yeah, the ethical limits of solicitation.
Okay.
That would be 103.
So for this one,
Yeah.
the question was really, I went back to the question that was actually asked to us, and I'm a little confused. So it says, lawyers soliciting favorable online reviews from clients, similar but different to the COPRAC opinion from 2019-199. Can you ask a client to post a favorable review for you and the issues related to that? So I looked into it, and by first starting with reading what was previously published by us in our opinion. And that opinion covered more sort of like attorney, they were like soliciting sites where attorneys could have profiles and then you could publish comments on the end. But in that particular publication, we covered pretty much what the ethical obligations were for asking solicitation in general. So all of this is covered under 7.2b, which says an attorney cannot offer any compensation, promise, or give value of anything in exchange for a request or review. So if you're asking for a post of an online review and you're offering anything, right? Even if it's like a novelty gift, it might be then prohibited under 7.2b, pretty straightforward. And then let's see, and there's exceptions under that rule 7.2b, but it doesn't apply to anything where it would be a client. If you're not asking for any solicitation, like, so it's the word solicitation that has me sort of hung up, right? Does that mean asking for money or asking without money? So if you're asking a client to post a review and you don't put any pressure on them, you just say, hey, you liked what I did, feel free to write a review online. You probably can do it. I didn't see anything that actually prohibits that. But again, 7.1 that still establishes that like fundamental prohibition against false or misleading communications about legal services. So if you're asking, then you may have an obligation to follow up and just make sure that it's nothing false or misleading. In the ethics opinion that was out there, they were able to draw a closer line of why 7.1 applied because it was a board and therefore the attorney was adopting it as some kind of communication or advertising. But mostly the opinions that are out there online deal more with attorneys trying to correct misinformation and stepping over the bounds of confidentiality. And so there's a lot of stuff out there. Other states have had it on attorneys cannot use confidential information in trying to correct negative reviews. So that becomes more of an issue. So I don't know if this is something we need to pick up. I'm hesitant. I think it's kind of, everything's very clear. I'm not sure how this is so different from what we've already put out there. The same guidelines on asking a client to post a review is the same whether it was the board or not the board. So
I think it's probably covered by the previous opinion, but it seems like the issue is manipulating the reviews either by who you ask or how you ask or what you take from the ones who do respond, and that becomes the misrepresentation basically. Right. But you know, that, I mean, that happens all the time, and you see everybody on Amazon has a huge 5-star review, and you're like, yeah, because you go back and do something with the old bad reviews.
Well, so you can't do that, right? What we can't do is like, look, I just was traveling, right? And every hotel I stayed at said, oh, if you give us a free review, we'll give you this comp you a breakfast or I'll comp you coffee or something. You can't do that.
Right.
You can say, I'll give you something for a good review. And there can't be any like pressure because then we get into solicitation pressure issues under the 7 rules.
Yeah, and you can't say, give me a review, and then when everybody gives you terrible reviews, you pick the one that's good and emphasize that potentially. That could be, theoretically, could be a misrepresentation, I guess. But
right.
Well, I don't know that I don't know that it goes beyond what we previously discussed in the opinion, and also like 7.2 has been vastly simplified even since then. So, does anybody feel like this is worthy of doing something with beyond what we just discussed? I think they agree with you, Allison.
Okay. Yay,
Thank you. Okay, so you have another one, which is work product rights in a departing situation.
Okay, so this one, I sort of presented it last week, but not very well. So not last week. Oh my gosh, last month. Not very well, but I apologize. So can an attorney leaving a firm take their work product with them? This becomes an issue with the term work product, because work product is really a term of art for privilege, right? And so there's a lot of cases under privilege going about who owns privilege and who can waive it and all of that. My short answer is generally an attorney cannot take their work product with them when switching firms or leaving practice independently unless the agreement, regulation, or statute provides otherwise. So you can have an agreement otherwise, but in general, we need to bifurcate this into the work product that is part of a client's file that a client has a right to, that would then be, it goes with the client if the client requests it, right? Or the stuff that an attorney sort of makes that can include their impressions and their strategy, but also just like forms, other templates, other things that they have created as well. I'm going to call that for now client material versus internally generated attorney work product, because I didn't find good terms for it. So hopefully that makes it clear what I'm talking about. When I talk about client material, that's the stuff that would be in a client's folder that if a client requests for it, it has to go to the client. The client has an ownership, a property right to that file. So if an attorney leaves and the client wants to follow the attorney, that attorney can request that work product in that file, and it should go with the attorney then, right? If the attorney leaves and the client does not want to follow, the firm then would retain it unless the client asked for it and they can bring it to someplace else. And those are very well established. So there's not really too much on that one. But what about the attorney work product that is generated internally by the attorney, right? And this could include then stuff we might think of in the client file that would be what's sometimes called uncommunicated privilege, right? It's uncommunicated attorney privilege. Those are the thoughts, the impressions that don't normally
Work product.
get what?
Uncommunicated work product, right?
Yes, uncommunicated work product. So as you can see, this is not an area that I've dealt with very much.
Well, but it could also include, generalized work product that because you produced it at the firm says that's ours. Templates and outlines or game plans. Sorry, I might be preempting you a little bit here.
No, you're right. Templates, game plans. There was recently, so there's been a series of cases, but specifically Tucker v. Ellis, which the Superior Court, which was in 2017, and then a couple years later, Nelson v. Tucker Ellis in 2020. These cases sort of go together, and basically Nelson worked for Tucker v. Ellis. He created, he was consulting with a client on some matters, and they were doing research, like scientific research. He ended up actually publishing an article, like a law review article on the research that he was doing, and left the firm. Subsequently, there's a subpoena from out of state, and the firm releases some of the work that he had. And he claimed, hey, you can't do that. I'm the one who created it. I have the work product. And yeah, and so it went back and forth. But the court came up with one, California labor law is really clear. Unless there is a contract saying otherwise, and I'll quote it for you under California labor law, everything which an employee requires by virtue of his employment except the compensation which is due for him from his employer belongs to the employer, whether acquired lawfully or unlawfully during or after expiration of the term of his employment. So the court's like, it's very clear you didn't have an agreement for you to keep any of this stuff. It is the law firm who has ownership of it. So there's IP issues, and there may be trade secret stuff under the California Trade Secret Act. Again, I didn't look too much into those. That's an Uniform California Uniform Trade Secrets Act. Not my area of expertise. I know other people are, but those could be potentials. But if
another wrinkle on that, sorry to interrupt, but another wrinkle on that is that if you're an equity partner, you're not an employee. And so it's governed by the partnership agreement, which typically would address who gets what.
Right. So that there's fiduciary duties with that as well.
Yeah.
So if you leave as a partner, now you have fiduciary duties. You can't take something, or usurp for your own good. There's a whole bunch of there. But basically under Tucker Ellis, it really clarifies. So because the privilege laws or rules say it's the attorney who waived the privilege, the answer to the question, well, is it the attorney who created the work or is it the firm? And the answer under Tucker v. Ellis is it's the firm.
If you're
The
an
firm has
employee.
the right to waive it. What?
If you're an employee.
If you're an employee, yes.
Unless you
So-
have an agreement of this. Do
Right,
you think
so-
that it would be useful, or do that people think that it would be useful or helpful to have an alert sort of summarizing this? Because I do think it comes up a lot. People have sort of figured it out. It used to be a really big issue, and now people don't argue about it as much.
Yeah, so I've kind of drafted up some of this stuff already with, citations and things like that. If we want to do like an informal working group, we can kind of put that together.
Yeah.
Especially since I've
Like
never
an
drafted
alert type thing.
Yeah.
We love alerts.
Okay.
Okay, would you like to bring that to the next meeting and we'll circulate it? Well, first of all, does everybody think that this is worth having an alert developed?
And just with the understanding that if we are going to be moving forward with it, then we need to vote to accept it, and we'd also need to add it into our work plan and add the timelines for it.
The alerts go in the work plan too?
Yes.
That's going to have a chilling effect on the alerts. But okay. Novella.
This might seem silly, but so like if you're at an employer and you they give you a CLE and they give you CLE materials, you can't take those with you because they belong to the law firm if you're not a partner.
That's a good question.
Theoretically, they could probably make that argument.
Yeah. I mean, they can't take your CLE credit from you because you've now earned that, but I guess
the materials themselves, theoretically.
Yeah, that's like work product for hire doctrine. So yeah, theoretically, it's owned by them. And like the slides, for example, might have like a copyright thing. So even though you might be able to find them by, like if they submitted them to the bar, theoretically they would be owned by your employer.
I know one of the other issues that came up in the AI working group kind of related to this was AI and work product that was created using AI. So that may be something that the committee wants to include as well. And if so, we're probably looking at an ethics opinion versus a legal alert. But I just wanted to put that out there for consideration as well.
Because I'm also in that committee. That was more about duty of confidentiality and whether or not if you took something from one firm that had, let's say, your former AI and you brought it to another firm, would that then cause confidentiality issues? I think that's that might be a kick down the road a little bit than this right now, if that makes any sense. I'm not giving you a good argument.
Yeah, to sequence it so that the AI group goes first and does its thing. Okay, so the question is whether this is an issue that would be suitable for an alert, or whether it is the type of thing that has been sorted out for the most part and wouldn't be news to people who are in these positions. Any thoughts? Does anybody feel strongly that it should be an alert?
Allison, what were you recommending?
I didn't last meeting, you guys. I actually came in last meeting and said I thought that this was pretty out there, and it was not too hard in like a Google search to find the answer, and therefore I didn't think we should take it up. But then as I was talking about it, people were like, "Oh wait, I didn't realize that." So that's where the idea of making it alert became.
Yeah. I think of the alerts as the type of forum where we would summarize and synthesize things that even may have been developed, but people might have questions, or where it would be useful to have an alert saying that this is how it all fits together. But, it's probably not exactly what the alerts are for.
Yeah. I mean, I love this as guidance for like my law students leaving, the school, like they should know that, right?
Yeah.
That when they negotiate with employers to know, hey, what you're producing is the firm's.
Okay. Well, based on the committee's general sense as perceived by the chair, I don't think we would do an alert on this, and we would thank Allison for this insight. And now we all know these things for sure, and we'll move forward.
Yeah.
And tell your law students about it.
I just real quick to everybody, I really appreciate everyone's patience with me. When I volunteered on, I was just working as a professor. And then since then, I started at a firm as well. So I've added in going back to litigation and also just doing will, stress, and estates, which I never did before. In 10 years, I haven't been practicing. So I took on all that at the same time. So I just appreciate everybody's patience with me as I'm.
Well, I think you should start playing the piano or something like that. Throw that in there.
Overachiever.
What are you doing between midnight and 6 a.m.? Do something, really.
I'm still up working.
Right.
And you have a family.
Yeah. Yes. Thank you, Allison, for that, and especially in light of all these new busy obligations that you've taken on. We have a list of new ones, and I guess I'll come to Rachel for this. There's 4 that came in through different channels.
Yes, correct. So Karen's going to be pulling them up and displaying them.
I have a question as we do that, and it's sort of it's related with this work plan idea. How once we concretize our work plan and the trustees say, I don't know if they're approving it, I'm not sure what their, what the decision point is, but how is that then going to affect this process where we've established where we're now every meeting saying, do we want to add things? Because that seems like once you say this is your work plan, you shouldn't probably be adding stuff until you're finished. But how are you envisioning this working, Rachel?
Yeah, I mean, that's something that we are going to have to figure out because I think COPRAC is a little unique in that we get these requests year round. When I was looking at some of the other committees' work plans, they did subcommittees of the Board of Trustees. They included some language about, being able to modify things as necessary. That may be an option. But I want to be very careful about overextending ourselves, especially while we have these older opinions, until we can kind of push some of those out. I just want to make sure that what we are signing up for, we are going to be able to meet, because the Board of Trustees is going to be overseeing the work plan. But in terms of the approval, it looks like it is submitted to the board, they review it, and then they ask me if they have any particular questions about the things that COPRAC is working on or any specific concerns. So I would be able to report back on that piece of it after the February board meeting.
Well, I'll add my 2 cents. The way that I view this is that we are going through this as sort of a pipeline. And there are a few steps that we like for these other ones where we go through the topic and see if somebody wants to take it up and look into it more, come back and say, yes, I think it's worth doing something. And then at that point, we would say, tell us what the thing is, and then we would consider putting it, say, on the next work plan, something like that. But instead of having these all pile up and having 50 of them at the end of the year or over 5 years and they just drag along, we really process those, and now we're considering them. And some of them won't survive this meeting, and some of them will, but they would probably be a pipeline for the next work plan, is my thinking.
I think that makes a lot of sense. And that helps address the issue that we were having where these requests were lingering for sometimes years and not being addressed. And like you said, some of them are quickly disposed of in a meeting, and then the requester gets a letter letting them know that, and then the others can, go into the pipeline for when some things open up, when we get some things out and put onto the next work plan.
Novella.
Do we put consideration of new requests on our work plan to show that we're using capacity on that?
No, I don't have that on the work plan, but we can add it when we get there.
Yeah, I think we should just.
That's a good idea.
Yeah. I mean, the problem that we're trying to solve for is the fact that these go on a list and then they stay on the list and they kind of trail. And remember, we went through and cleared a bunch of them, all of them. And then the other thing is the effect of that is that people submit something and get letters back years later that say, we decided not to do this thing, right? And that's not a good way to proceed. So it wouldn't be like we're going to have to add it to this work plan or that we're going to commit to doing something right now, but it's sort of pipeline stuff.
Thank you for the clarification.
Okay, so this is in the pipeline. What is this?
This is the
Oh. Okay. I thought that these had been emailed out to the entire committee for review, but I don't think they have. So maybe it would be best if we hold these until March so that they can all be distributed and everyone can review them. Because some of the requests are several pages long.
I think that would be a good idea. So we'll do the same thing in the next meeting. It's fine to make some time. But when these get circulated, look at them and see if there are some that you think you want to make a case for us pursuing more, and we'll sort of pipeline it if everybody agrees that it's worth thinking about. I still think it's positive and very helpful to have these things be assessed, even if we decide not to pursue them, because that's our job. One of them. So, okay, we'll do that on the next one when the materials go out. Let's come back to client file release and retention. Okay, anything else on new ethics opinions, rules, and other requests, Rachel?
No, nothing else on my end.
Okay. We'll come back to Emil. Yes, client file release and retention duties.
We already discussed that. I think you might be talking about ethics of in-house counsel, former client's IP.
So I am. Yes, thank you.
Perfect. We have already, when I came on board, we had another draft. Carrie, myself, and the rest of the team came and really just revamped this completely. And we submitted it to staff who made some edits for us. And I guess we're looking to see if we can get it voted out. So, Karen, would you mind putting that on the screen?
Yes, I'm pulling it up.
And kind of for context, we're talking about like lateral transitions or just conflicts of interest that might apply when an attorney, for example, moves from one in-house employer to another. So this was, I think it was something that came out of the other ethics of in-house business transaction with clients. It was something kind of similar in that same vein.
Yes.
So we ended up coming up with this. There's a red line, and then in the materials, there's also a clean version. So I don't know where we can begin. I did, by the way, I did see that the supervisory capacity was addressed further in. So
Okay.
yeah, and maybe if we can scroll down, I think there's the footnote 1 is some cleanup edits, which is great. I think I would like to potentially mention those opinions that So-Yeon put in. And then I think we can go further down. Okay, keep going. So one, this has to go out for public comment because this is totally different than what we originally had and just needs to go out because I think it's different than anything that we've come up with before. The idea behind this opinion is just to let people know that conflicts apply to in-house counsel. Because I think it's something that people don't know about. It starts with the definition of firm or law firm in the definition section. Firm or law firm not only includes a law firm, but also the legal department of a corporation. So in this case, we're going to be talking about not only maybe the idea of disqualification, which is kind of thought about on the periphery, but also just the dangers and what people should think about. So if we go all the way to the end, there's a section that we kind of refer to like as top tips, all the way to the end of before the conclusion. We ended up calling it, no, keep going. Key considerations. And I think this is one where we have a lot of red lines from staff, but I want to kind of understand the committee's consensus on something like this. When, what we have above is cited with authorities and, it's an opinion, but it's still cited with legal authorities, what California courts are saying about something. And key considerations was really like, if you're thinking about this, you should be considering these issues. They don't necessarily line up to everything that's in the opinion, but it's more like these are questions that you should ask yourself. Like if you're transitioning from one employer to another, or if you're hiring somebody from your number one competitor, here are things you should consider. And it's not necessarily these are the rules that you should consider, but these are things that you should ponder prior to making that transition. So that's kind of a roadmap of what this opinion is. Carrie, do you have any thoughts? No? Okay. So I guess let's see if anyone has any thoughts or questions. Did everyone have a chance to kind of look through it?
Well, I will start by saying that I like the key consideration section a lot. I think this is the type of thing that would be very high value. And partly it's not that it's obviously not a synopsis, not a summary, but it's okay, so how do I start assessing this practical way? And then if you have answers to these questions, you can go back up and peg it to particular analysis. But I think it works really well because the other material is extremely dense by necessity, and it gives people a takeaway without reading every footnote and doing everything. A place to start makes it more accessible, I think, an entry point.
Okay. And this is a more procedural question for Rachel. So, for example, we have not incorporated those ethics opinions or that case that was cited by staff in our draft. So if we were to vote this out today, and because this is still in red line form, how would that be done?
I'm not sure it can be voted out today just because there are, I think for that exact reason, is staff provided some comments and some suggestions and some red lines. And so, unless we can figure out right now what we want to keep, what we want to get rid of, I don't know that staff would know what version of this we're sending out for public comment.
Okay. And timeline wise, just because, and I apologize, I missed 1 hour of the meeting, but it sounds like we've put a lot of things out for repeat public comment. And in this particular instance, this would have to go out for 60 days.
Correct. This has never been voted out for
Never.
public comment before.
Okay.
So if we're following our internal guidelines and procedures, we would want to do 90 days to get the initial feedback and then revise from there.
Okay. So
we do have plenty of time on this one because it's currently slated for Q4 of this year, so
Okay.
December.
Perfect. Yeah,
I think Emil and I thought we had to get it out this meeting.
yeah, that was I think that was our understanding. So we were kind of rushing through and part of it was I think I understood that last year we didn't issue any opinions, and we're trying to move forward. I obviously we want to spend time with quality and all that. We're trying to balance it. So here's what I would ask. It's not a motion or anything, but if anyone has any comments, if they could let our working group know. Carrie and I are I think the only ones in the working group on the call right now, but you let us know any comments that you might have. We'll try to get these wrapped up in the next 2 weeks, send it back to staff for final review, and then hopefully aim to vote out next meeting in March. That would probably right. March is the next meeting.
Yes.
Yes.
Yeah, because after March, when is the next meeting after that? Because the symposium's in April, so would that be
May.
May?
May.
Okay. So yeah, I think I would like to. So Eleanor just asked if I could send a copy. I'm happy to send a copy of this. It's also in the materials, but I'll send the Word version just so you have it. I think that would be great, and this way we can kind of have an idea of what everyone wants ahead of time, and then hopefully not have to make any changes before we vote it out next month. Allison?
So when I was reading through it, I had this is really very good, but I had one question. So you're talking about lawyers who are working as in-house counsel or being privately obtained for like a one-off, right? What about attorneys who are working for a corporation, not necessarily as legal counsel, but they are somewhat doing legal stuff, maybe in compliance or in the tax area or something like that? Would then they also fall underneath these this as well?
Sure. So we were actually talking about lawyers that work for in-house counsel as in-house counsel that go to work for another employer as in-house counsel. In-house lateral transition. So but in terms of to your question, that's a very nuanced question. There's a lot of ethics opinions on that when you're in a non-legal role, what your job is, and it's very factual. We don't actually cover that. So I think your question is like a JD Advantage job. If somebody goes from a JD Advantage job to in-house counsel or in-house counsel to a JD Advantage job, does that impact the analysis? And the answer is no, we did not cover that in here.
Right. I didn't see that. That's why I'm bringing it up.
Yeah.
I'm wondering if that needs to be covered as well, because that happens, right? More often.
Yeah. I haven't really thought about that. And I mean, I'm open. Does anyone else think that might be helpful to add in here?
I mean, I think it could be at least mentioned, but I don't think it would necessarily be that different, except that you'd be coming in, depending on which direction you were moving, you'd have multiple clients versus just one.
Well, the JD Advantage person does not have a client. There's certain ethical obligations, but like your 1.6 obligation does not necessarily apply. You may still have fiduciary duties to your, former employer and trade secret issues, et cetera. But I think the analysis is quite different. That's why. So that's the way I look at it. Unless again, I haven't spent the time to research it, but unless somebody has, Carrie, what do you think about that?
Under 1.6,
yeah, look, under 1.6, 1.7, and even 1.10 and 1.9, right? So if
not 1.7.
Yeah, if somebody goes to if somebody's working as the compliance manager for a pharmaceutical company at, let's say, Abbott, and then they get a job as in-house counsel at Pfizer. While at Abbott, they were not acting as a lawyer. So they have certain obligations, but they're not 1.6, 1.9 obligations.
They are a licensee, though.
I don't believe it's the role that they're in. I believe it's their licensee status that determines that.
They may or may not be licensees, but if they are, then
if they are.
But let's hold on for a second. So do you have a duty? I'm a licensee. Do I have a duty of confidentiality when a friend talks to me about non-legal stuff? No, right? Not covered by 1.6. So when you are in a compliance role, a non-legal regulatory and compliance role, does 1.6 apply? And then therefore do things like 1.9 apply? And
There's cases on it that talk about exposure to material confidential information in it talks about non-lawyer roles and how that still can be a disqualifying conflict. So I think I think the same rationale would apply here. Just because you're a compliance manager, you still owe certain duties to your former employer.
so I think those might be fiduciary duties, and I think there may be a DQ issue, right? That a court DQ issue, but
I guess that's all I think about.
okay, yeah,
I think it
I'm
depends
looking
on
at it
what
from
you, yeah,
the
I
state
mean,
bar.
if you have a license and you're doing law-related type stuff that's compliance and looks a lot like being a lawyer, I think it would be very difficult to argue that you don't have those obligations. But that's a sort of a separate topic.
Sure.
Yeah, but I see your point, which is that if you didn't have a law license, they definitely wouldn't apply to you. So
Correct.
why should have a law license in the exact same position, have these different requirements? And I mean, the answer is because you have a law license, right? But
Yeah.
we could talk about that, but I do think it's a separate issue.
Yeah. And California doesn't have like 5.7 too, so
Right. But we just look to the model rule on that. So that,
yeah.
but I mean, and this is limited to in-house lawyer and I think it's a very timely thing. These things come up a lot because increasingly in-house lawyers are specialized in particular industries like tech, for example, and they're moving from one position to another, and they're much more likely to have conflicts based on jobs they're qualified to do in-house.
Would you be willing to put maybe in one of the footnotes then that that's out of the scope? Because as somebody who had worked as an attorney, but not in the in-house counsel, I was always interested in whether or not those things apply to me or not. So
Sure.
I think maybe making it clear that that's outside the scope of what you're talking about.
No, I think that's a great idea. And actually, I don't know, Rachel, if Allison would be able to join our working group. Is that, or you don't want to, or it's fine. If you don't want to, that's
I'm
fine.
sorry, I'm at capacity.
No.
She's
no
got
no
piano
worries.
lessons. She can't be doing that.
Okay. So I will put a note to add a footnote regarding non-applicable, like we're not covering non-lawyer transitions basically,
Yeah.
or transitions made by lawyers in a non-lawyer role.
That sounds great.
Perfect.
Eleanor.
Is that too broad? Because you want to capture like law clerks and things like that. And maybe just a little overbroad.
Oh, I see what you're saying. Yeah, because there's special rules about law clerks.
People in government who may be in a not practicing role, but still are going to be.
That's under comment 4 to Rule 110. If we want to.
Okay. Yeah. Well, Carrie, you and I can kind of talk offline, and then Eleanor, I'll also send you the document just so that you can provide some comments when you have a chance to. Okay.
Okay, great. This is in very good shape. I think it's in really good shape. Thank you guys for this.
Thank you.
It's an interesting and a very important one, I think. You've also lapped the other in-house counsel opinion, just FYI.
Don't tell Cassidy.
That's not true. Actually, it went out for public comment again. Yeah, sorry. Okay. Anything else on this? The idea was you'll make these revisions and assessments and come back with a revised version before the March meeting, at which the goal would be to vote it out for public comment.
Yeah, sorry, we thought it had to go out today. So now I'm like relieved that we have all year.
Everybody should be thinking exactly like that. That's how we should be thinking. That's good.
Great. Thanks, guys.
Okay. We are at the 2026 work plan, and this is the time to finalize it and vote it out. Yes, Rachel?
Yes.
Okay.
And we're getting it pulled up. So Karen's going to be displaying it, but I'm also in here. And I'll be taking notes. Can we go down to that, just the very first row, the 19004?
Yeah.
Perfect. So this is the one that needs to be reworked because of the change in the penal code. I think I originally had it for Q1 or Q2. I moved it to Q3. If we come back in March, it's gonna need to go out for public comments again. I don't know if Q3 is gonna work. We might want to move it to Q4.
That's, I mean, even if we moved to Q4, we could still bring it earlier, right? Yeah.
Yes.
Yeah,
I'm okay with that.
I think that's right.
Okay. And then I also had a question here just for all of COPRAC. So on some of these, we'd added in the new roles, our internal roles that we had developed, not on this one. Let me see if I have an example. Can you go down to the 20005? So for example, here we have the lead, the editor, the scheduler. Those are just internal comments for us. I don't think the board necessarily needs that information. So I just wanted to check with the committee to see if you would like us to include that on here or if you would like us to take that off.
I think those should remain internal because we don't want it to be somehow something that is part of what the board is evaluating because it's really internal, informal work plan guidelines for ourselves.
So any of those that I've put in there, I will take out. We have been including the lead designation. Do you want to leave that or should they take that out as well?
I think it's fine to leave it, but you can also take it out. I don't think that the board is approving that part of it. It's really not part of what they're approving. Those are just internal
it's not.
designations.
Those are just like, yeah.
And that does change from time to time, so we wouldn't necessarily want it to be something that's like board approved and then it's different and then what we'd have to do.
Okay, that makes sense. I'll take all of those out. Okay, and then just another note to myself. These were just the notes that I had been keeping on our 2025 work plan, so we could all see where we are. I will be removing all of these comments before this goes to the board, just so that the committee is aware.
001, for example, I'm still working on that. There's a ton of public comment that I'm still working through.
I think we will still have time to meet the Q3 goal. If we want to keep that, I don't know. What does the working group think?
I think so. We decided to take out or tone down a section that was causing the most heartburn in public comments. And then it's just a question of going back and doing the refinements, but it's conflict analysis. And so it's intense and some slow going. But I should have a draft that does those things to the working group. And then we should be able to come back to March with a new one.
Okay, so the Q3 works then.
I think so.
Okay. Can we go down to the next one, Karen? Okay, flat fees and termination. Why don't I remember the status of that?
So Mohabi, Ali, Brown, and Joyce.
Huh.
The last note I
Isn't
had.
it ready? Isn't it ready to go out? It wasn't on the agenda, right?
It wasn't because staff had incorporated some of the public comments. There were some outstanding things that the working group needed to review, I believe.
So I just emailed about this because I noticed that I thought the working group was signed off. I think that the only thing that folks had to do was just sort of because I'd gone through in the last round of public comments and just like kind of nixed Most of them agree with staff on the rest, and I think we were all sort of in a position to be to vote it out. But if we can wait till next week, I mean next session, that's fine too. If folks want to take a look at it.
Okay, so we can keep the Q2 goal because we'll be voting it out in March. Okay.
So let me clarify, because I too was like Nima. I thought the working group was fine based on what Nima said. So what are you expecting from us, Rachel?
I apologize. My email is still not downloaded on my new computer, so I am operating half blind here.
Okay.
But the last note that I have on it was that the working group needed to respond to staff incorporation of comments, and if substantive changes were made, it will need to go out for public comment again. But let me check our SharePoint too.
And so based on that, you're saying as far as you know, we weren't responsive to the last set of comments. That's what you're. Yeah. We may not have. I know internally we had
Okay.
some dialogue.
I can connect with the working group offline after this meeting once I have my email up and running again.
Okay.
And I can let you know the status of it and if anything else is needed, but it sounds like either way we'll be okay with that Q2 goal.
Yes.
Okay, so conversion clauses and contingency fee agreements. This one we talked about today, correct?
Yeah.
Yes, you voted it out for the 60-day comment period. So I think that this Q4 still looks good. In the event that changes need to be made, that will give us some cushion to vote it out for public comment period again and still meet that goal. What does the working group think?
Seems reasonable to me.
Okay. Ethics of in-house counsel business transactions. This one was also voted out for public comment 90 days. I think that this, based on that, we'll need to move this. I don't think it's going to be Q2. I think Q3. Does that work for the working group? Public comment would return at the very end of April, probably beginning of March. So we would have it back before our March meeting.
That makes sense to me. I mean,
And
I voted
if
against public comment, but makes sense to me.
okay. If the committee is okay with it, when I do my final review of this, I will probably end up adding some either or here just to incorporate a second round of public comment if something is going out for the first time, something like that, just so that we have a little bit of leeway in terms of our deadlines, because given that basically the entirety of the committee's work has to go out through public comments, it really is dependent upon the public comments we get back and whether or not changes are need to be made. So I'll try and go through and account for that as well, and maybe propose some alternate deadlines based on additional public comment period. Okay, so next up is cryptocurrency. Does the working group think that we can meet the Q2 deadline, or should that be adjusted?
Why don't we leave that for now? It's It's close. I set it on the back burner, focused on other things, but I think I can probably get that out to the working group for comment. And since it's an alert, I expect it'll move more quickly. So hopefully we can be ready to share something at the next meeting. I mean, you could put Q2 or Q3 if you wanted to put a cushion in, but I think we'll be able to move it out now that a few other things have moved.
Okay. I'll keep it in Q2 if that works for you guys, just because I think our work plan is pretty heavy towards the end of the year and lighter towards the beginning.
Okay. I think that works.
Okay.
I also think Q2, because I think we should start progressing on something for this. We had it too long.
Okay, sounds good. Okay, this is the one that we just talked about. So I think we will have no problem meeting the Q4 goal if we're bringing it back in March and voting it out for its first round of public comment then. We'll come back in June. We need to vote it out by the October COPRAC meeting. I think that timeline works. What does the working group think?
That should be ready to go by March. I think that's close.
The attorney adjacent work and handling retainers and fees. That's one that Cassidy indicated she'll be bringing the completed outline to the March meeting.
Yep.
So this is slated for either Q4 or Q1 in 2027.
Yeah, that's right. For the outline in March, I think that's still good.
Okay. And oh gosh. And I believe this is the one that, yes, staff is going to be drafting this after we receive the outline. The ADA fee arb opinion, the working group is aware. I've been working with our Office of General Counsel and the arbitrators to get some clarification regarding some questions that the working group had, and also get some direction from the Office of General Counsel about what COPRAC can and cannot opine on. When the fee arb committee was subsumed into COPRAC, I'm not sure that there were any guidelines or kind of guardrails put on the fee arb opinions. And so now that this one is being brought up, I'm just working with our general counsel's office to make sure we are staying on track in terms of what can we opine on, what can't we opine on. So I'm working with them on that, and we have a very detailed outline ready to go. So I think as soon as we get direction from them, we'll be able to start moving on this one. But I do have it slated end of this year or beginning of next year. Novella and Raquel, does that sound good to you guys?
Yeah.
Okay. So I added this in after the working group kind of determined its direction for the request from the Supreme Court. So it's pretty general right now, just because we're still working on the proposal. And I am, again, working with the Office of General Counsel to figure out if we are able to shorten the public comment period or what the process is in order to get these out as soon as possible. But they will need to go out for public comment, obviously. So right now I have it for the rule changes related to AI. The deadline is Q3 this year and going to the board in July. So we would need to vote it out at our June meeting to go to the board after public comment period. Any comments, questions about that?
Yeah, I have one.
Yeah.
This seems to assume that there is going to be a proposed rule change, which I think we think is likely with respect to at least comments. But But do we want to do that in writing now with the board, or do we want to? I think that gets a little bit ahead of where the working group is. Nima, do you have a view on that? You're leading the group.
No, I was gonna say, I mean, unless we need to actually put something down on this, I tend to agree with that. I think that we can certainly shoot for this, and I think that we are shooting for it. We'll rightly hit it. But I don't know that. I mean, do we need to kind of? It's always like, do we need to sign the name in blood, so to speak?
So we will need to provide an update at the very least to the board on the status of any proposed rules of professional conduct changes at the May meeting. They very well may still be out for public comment or in development, but we will need to provide an update at the May board meeting.
Okay, no, but like, so instead of, so I guess my question is like, instead of just, what can we just say that? Like, we'll provide, like, we'll be ready to, all of our proposals are gonna be done by the May meeting. They're gonna be done in March. So I don't know, I don't know, the way, like, yeah.
My concern was that we're perhaps getting ahead of where we've landed, because there's been no recommendation yet. We have not started drafting rule changes or proposals to change the rules. We're going over the guidance first. So when we get to that, it's possible that the decision will be made that it's not necessary. I think we all anticipate comments to be proposed. Sorry, go ahead.
I was saying possible, but I think highly unlikely. But
I think it's unlikely, but are we committing ourselves to a rule change before we propose one? That's the issue I want to raise.
Yeah.
Oh, I see what you're saying. I didn't understand. I apologize, Eleanor. I see what you're saying. Well, I think that given the direction from the Supreme Court, where it specifically asked COPRAC to consider incorporating some of the practical guidance into comments to the rules, I think that's a pretty clear indicator that they would like us to do that. But I see what you're saying in terms of the work plan, and are we committing to something when we aren't sure if we're going to be doing it yet?
Raquel.
Like AI. Oh, sorry, Raquel. Didn't mean to interrupt. Go ahead.
No. You guys finish. I'll come in after.
Okay. I
Yeah,
was just going to suggest maybe we say, AI and then like a dash, updates to guidance and any amendments to RPC or something like that, just in case, just leave it open until there's been a recommendation formulated.
Well, I'm just struggling with that just because of the way that this is formatted. Because we have artificial intelligence down below under articles and alerts. And then this is specifically in regards to the rules of professional conduct.
Michelle,
I'm wondering if there's a way we can change this phrasing to make it a little more broad.
So, okay, what about, is our work that we are doing at the direction of the Supreme Court incorporated in this work plan anywhere else besides this item, Rachel?
Yes, if you want to scroll down, Karen. So
Okay.
it's also incorporated here under articles and alerts. We have our artificial intelligence working group. And then the other direction that we received from the Supreme Court was regarding civility, and that's also in here as well.
So, okay, go back up. Can you go back up to, yeah, right here. Okay, so this is the practical guidance. Practical guidance that we're doing. is there some reason why you called out the change to the rules of professional conduct separately, since as I think Eleanor and Nima pointed out, whatever happens with that is gonna come as a result of what the working group is doing on this? I mean, I realize, it's a bit of a difference because you've now got work separated by topics. So that then makes you fragment something that is not fragmented in terms of how it is being developed. It's not being developed separately, it's being developed together. So is that why you separated it out, the rules of professional conduct, from the place in which that decision will be made, which is under articles and alerts? Which we didn't actually, I mean, I guess it's, I don't know. I get, the practical guidance always is going to go out as an alert, or how, I mean, how does that, why is that under there? Because it's not an opinion? Is that why?
Right, because
Okay.
it's not an opinion. The practical guidance did go through the board the first time, so it will have to go through the board this time as well.
Right.
But I think we can just take out, if you could scroll up, Karen, I think we can probably just take out this completely since it is covered in what's below.
Okay.
If that works for everybody. I can't see anyone except who's speaking. I'm just looking at a Word document.
Yes,
That works.
Okay.
Okay, thank you for the clarification. That, I think that would be helpful to put it
perfect.
together.
So the DA ethics alerts, if we're coming back in March and deciding where we want to go from there. I mean, this is another one that's kind of turned into we aren't sure what direction it's going. Does the committee have any suggestions for how we should present this on the work plan?
I think it should go to 3 because if it ends up being a proposed rule, it would have to go up for public comment.
Do we want to do this?
Yeah. Yes.
Okay. I'll have to put it there. Okay. I also wanted to review the artificial intelligence portion of this. I'm going to delete all of this. I would like to give the board a little bit more context for this item, since this is one that the board is particularly interested in. I'm also going to be, just to give the board a little bit more context about what the working group is doing. So I guess I can put possible amendments here. But how does that language look to everybody?
Yeah, looks good to me.
Looks good to me too.
I think we are missing 2 members of the group, if it's right, which is Allison and Aaron's in the, I don't remember if Aaron's in the group, but Allison, right, is in the working group.
Yeah.
Yeah, I
You're
am.
talking about artificial intelligence?
Yes.
Yeah.
Yeah,
I
you're
think
the
I
one.
said we're
You're
supposed
the
to all be putting our
scheduler.
comments on the latest version that is in the folder, which I did.
Right. But we're just talking about like the
members, the
Aaron.
membership. Yeah, you're not on the, you and Allison aren't on the membership.
Oh, I see. This isn't updated, yeah.
Yeah. And so shouldn't we be explicit that this work group is related to the Supreme Court request in your description?
I can put working on several projects at the request of the California Supreme Court.
Yeah, I mean, just because you said you wanted to be more explicit to the board. So since they sent it to us, that should remind them of the, what this major task is.
Does it matter that there's pending litigation, there's pending legislation that may change some of our recommendations to allow mandatory things if the legislation goes through. So that may push us back, depending on how long it takes for that to go through.
I think that the working group, I mean, has to proceed with the practical guidance and the possible rule changes. I mean, the rule changes that are being proposed in the legislature are related to the Business and Professions Code, which, as we know, there are rules regarding confidentiality in the RPC and in Business and Professions Code. I think if COPRAC decides that they want to do something to the rules of professional conduct, that's fine, and the legislature can keep doing what they're doing in terms of the Business and Professions Code.
I mean, it impacts though how attorneys can act, right? I'm just saying being practical, that it may push these deadlines back more, even if we're trying to get it out. If we put something out, but now the legislation has certain things that are mandatory and we're saying things are, optional or just to look at, we would have to reconcile that. And so I don't want us to promise something and then be stuck with a timeline that's not practical given.
Yeah, sorry. Just to jump in, I think that, I mean, that's a good point, but at the end of the day, like, because they put specific, like they've asked us for something, so we have to give them something, whether or not it's something that we say, hey, like, this might not, if there's a legislation that comes in that ends up getting passed, like, that affects it, like, we raise that issue, but we have to go back to them with something, I think is what I have the issue. Is that right, Rachel?
Yeah, I mean, we have a pretty clear directive and request from the Supreme Court. I don't know if I should add in any other deadlines here.
Like internal deadlines?
No, just deadlines, anything related to the board. Because this is supposed to be our timeline. So I mentioned here, possible amendments to the rules, updating the practical guidance and outreach and education initiatives. But the only thing that we have here in our deadlines is the practical guidance. So maybe we need to add in other deadlines.
In terms of the when we have to, like, the stuff that sort of follows it, is that what you're?
Yeah.
Okay, yeah, no, that makes sense.
I mean, I can say Q2 at that May meeting, it would be update on status of potential rule changes.
Yeah.
And then I guess we can say, because we also have that draft email regarding AI hallucinations that can go out. Probably, I would assume in Q2. What does the working group think?
Yeah, no, I think so too.
Because I mean, that's an outreach and education initiative. So I think maybe for those, we can just say Q2 through Q4.
Yes. That's broad enough to say anything, but specific enough for them.
Mm-hmm. Okay. And then I'll just note that any rule changes will need to go to the board as well. Anything else on AI? No? Okay. And then civility. Delete that. Okay. So I don't know. I feel like we should probably come up with some sort of description here, similar to the description that we did for AI, since this is another request from the California Supreme Court. Does anyone have any suggestions for language? Let's see.
Just track the request, I think, is the best way.
Yeah, I think that's right.
I'm sorry, say that again?
Tracking the language of the request. You can say reviewing cases, to propose codification into the rules.
What quarter should we put that in?
I would like to put it in Q3 and aim for Q2. But I don't want to miss. I am mindful of we're pushing hard on AI. So.
Okay, I'll have to pull the Board of Trustees meetings and I'll put whatever the last Q3 meeting is for the board.
Is the civility team comfortable with that? I don't think we can safely go any further, so I'm trying to buy us as much time as possible. I'm not sure we'll need it, but
Your 3 seems fine.
okay.
Thank you.
I don't think anything needs to be added to the ethics symposium.
Yeah.
Okay.
Is the civility toolkit something we would put on there, even though it's sort of in process?
No,
Okay, no, all right.
since the civility toolkit is being produced by OPC, it wouldn't go on to
Okay.
COPRAC's work plan.
Okay, other than we provided input.
And that's past work too.
Yeah, okay.
We didn't. I mean, we did a review and gave some light comments. So yours were more robust. So thank you, Raquel. But I do think it's past work.
And then I don't know if we need to include the COPRAC membership on our work plan that will be dealt with today. But I did put it on. And then remind me, I'm sorry, somebody suggested something to add to the work plan earlier. And I don't remember what that was.
Oh, that was Novella, right? She had.
Consideration, I wrote something, or is November here?
When
Was it
new
the-
requests come in?
Was it the
Yeah,
1.7 revision from Carrie?
It was the consideration of new opinion requests that Novella
Right.
mentioned. That's right. Yeah.
Ongoing consideration of requests and decisions, and then this is something I added. Decisions consistent with whatever we had our work plan rubric, so we sort of went through and said, here's how we're going to be making decisions.
Yes.
Which then I'm adding a little bit more, which makes me ask the question, is the thought we would attach this to our work plan so the board has context for this work plan? Rachel or Dan?
Would we be attaching the new opinion requests? Was that the question?
No, the question is, we went through a exhaustive process. I don't know what the document is called.
I
Right,
see.
that basically framed out, here's how we're approaching our work to include our work plan. So how we're making decisions, what kinds of things we're opining on. So I don't know, we have never talked about sending it, but I would suggest we do because it goes to the idea of, we are going to be considering requests, because we say that in our narrative about how we do our work.
The plan is not to send that informal internal
Document.
guideline because it complies with
Okay.
the rules, and we don't want the specifics of that informal plan to be approved by the board and then have it be a board action.
Okay. All right. So I get that. I understand that.
So it will be reflected here because they otherwise wouldn't see it that we're
Yep.
doing.
Right. Okay. Thanks.
So does the committee want to keep this COPRAC membership line? I do like the idea of bringing it onto the agenda and discussing it every year.
I do,
don't
because
think
I think it just spurs the pipeline for people to think about colleagues that we might get a better sort of cross section of candidates and more people.
Okay. And I believe that was it. Is there anything else, Karen? Okay, that's the end.
Beautiful.
So if everyone is okay with it, this will be, I will go back in and clean it up and make sure that I'm taking off, the lead and the other things we talked about. And all of these notes on this column, except the ones that are specifically for the board. But is there anything else that we needed to edit or modify with the work plan?
No. Do we want to have a motion and a vote to send this out? Do we need that?
Yes.
Okay.
I'll move to send
Okay. Eleanor moves to send it out with the revisions that we just discussed on the record, and we need a second to that motion.
I'll second it.
Nima seconds.
Okay, I'll take the vote. Ali,
Yes.
Brown,
Yes.
Coleman,
Yes.
Guzman, Joyce,
Yes.
Matt Watkins,
Yes.
Mercado,
Yes.
Mohebi,
Yes.
Perlman, Perlman. We can't hear you.
He's
Hear
trying
me?
to say yes, but
I said yes.
Thank
We
you.
heard that. Thanks.
Yeah, we heard that one.
Poindexter, Riley,
Yes.
O'Reilly.
Yes.
Okay, 11 yeses, the motion carries.
All right. That's a work plan. Great job, everyone.
10,
Now
sorry. For the record, 10 yeses, the motion carries.
Okay. And thanks to Rachel and Karen and everyone for their hard work getting this again coordinated. Now all we have to do is the work. So, okay, that is the next item on the agenda is discussing membership. And let me tell the group, because I think it's helpful for everyone to know, that we need 2 attorney members and 1 public member. Does that mean, Raquel, that your term is ending? Is that what's happening?
It is.
I guess we're on the same schedule, so yeah.
Yes, we are. We came in at the same time. But you'll be staying on as an advisor.
That's right. I'll tell you all about it. Okay, so we've talked previously about the type of things that we like to have represented on it. One of the things we don't currently have is somebody who does arbitration disputes, as far as I can tell. And so that would be helpful to have that perspective because we are doing those. And we had that for many years.
Yeah, so, sorry, Dan, I have a question on that front. I mean, if there's somebody who's in an in-house position, but works, predominantly in arbitration, is that something that, I mean, how do we view in-house lawyers versus
I think it would be very helpful to have an in-house perspective, to be honest. We have several of these opinions that relate to in-house issues, and we have right now we have the perspective of outside lawyers and what they think in-house lawyers do, which is a little bit different. So I would think that would be very helpful as a perspective.
Are you talking though about RIHCs, or are you just talking about a California lawyer that's in-house?
literally just like a California lawyer who's in-house. I have two people particularly in mind that I think could be good at this and would be probably interested.
And I don't disagree, but we do have Eleanor, who technically is in-house as well.
That's true.
True.
What?
But she's in-house at a law firm.
No,
so
wait,
it's
what am I?
really
Chopped
hard.
liver?
And Carrie as well. You're
Carrie,
right.
duh. Yeah. Oh, yeah.
Boy.
Whoops.
You took
sorry.
one forward, one back. on that.
What I should be clear about is in-house at a non-legal sort of entity, like a tech company or a Fortune 50, something like that.
Rachel, just for my own edification, and sorry if everybody already knows this, but would a registered in-house counsel or like someone who is licensed in another state but not licensed in California, could they fill a attorney spot on COPRAC?
No, they
Licensed.
have to be a California licensed attorney. Mhm.
But they could apply for a public position or no?
I don't see why they couldn't apply for the public position. Because if they're registered in-house counsel here, then they're living here. So, yeah.
Eleanor.
I just wonder if part of the reason for the public position is to have a non-lawyer perspective on the committee. And
Yes.
we might compromise that perspective if we're seeking lawyers from other jurisdictions.
Let's ask one of our public members and get her view.
What's the question?
What is your position on, well, I don't know if there's an official rule, but the question is whether it would be better to have a non-lawyer in the public member position.
Yes, it should be a public, I mean, the intent is a non-attorney member, and I think that's the guidelines. You are serving as a non-attorney member. It doesn't necessarily say in the state of California or not, but yeah, we're supposed to be representing the public's interest or perspective. So I wouldn't add another lawyer.
To anything, really to anything, not just
no. But I'm just saying, I think is a benefit because my experience is it is a different line of sight.
Yeah, that's definitely the case.
Public office with that logo, I wouldn't add another lawyer. That's a great that's a great slogan.
That's your epitaph. Okay, so applications are due on March 31st. We encourage you to think about colleagues who may be a good fit in any of these roles: 2 attorney members, 1 public member. Again, arbitration experience, potentially an in-house experience, and non-lawyer public member with an interest in these issues. Current applicants, current members also may submit letters of interest on that same time frame if you're interested in applying to a leadership position in COPRAC. So I would be happy to tell you about how this goes, or Eleanor or Cassidy, I'm sure. But the first step in a leadership position on the committee is to put together this letter of interest that you would then send to the staff. Eleanor.
We had talked at one point about whether or not we'd consider expanding the committee or recommend that. I don't know where that conversation went, but I just wanted to check in. Is that something on your radar for discussion, or? It's
not, but it could be for future reference. I think that our numbers are dictated by the rules, state bar rules.
Yeah, I think it used to be larger, if I'm not mistaken, like Rachel, and there was some discussion about whether or not there was going to be a suggestion to expand it at some point. I just couldn't remember where that was left off.
Yeah, it used to be, I believe, 15 members and the advisor. And then with the sunset review in, I think that was just a couple years ago, a year or two ago, it was reduced down to its current formation, which is 13, including an advisor. There was some back and forth about reducing it to 10, but we landed with 13, including the advisors, where we currently are. But that is dictated by the board. So if at any point COPRAC wants to change that, then we just need to take it up with the board. But it was recently reviewed with the sunset provisions, where we're now able to opine on UPL.
Okay. Other thoughts about membership? Please do think about people that you think may be appropriate, and feel free to point them to the site where they can get more information about it. And again, the deadline is the end of March. Carrie.
You're on mute.
I had someone ask if I am allowed to write them a letter of recommendation. Did I freeze?
No, we
No.
just froze.
Oh,
We don't know the answer. Sorry.
that was wild. Everyone was, that was crazy. No, there was not.
You stumped us.
The answer is yes. Yes, you can. We have had prior COPRAC members write letters of recommendations for candidates while they are serving on COPRAC, so that should not be an issue.
Okay.
Yeah.
Great.
Okay. And Raquel.
Does COPRAC interview the candidates that you were considering, or just done on the paper?
No, they are interviewed.
They
Yes,
are.
they
Okay.
are.
Okay. Because I don't think I was interviewed, so it was being done on the paper.
I don't think I was either, but that was the last year they didn't, I think.
Okay.
Yeah. And look what happened. I mean, come on.
Yeah, you got great members. I think in the interview process, what I learned that I didn't fully understand when I joined is how much of the work is actually done outside of the meeting.
Yeah.
And so I think, people who really want to do it are going to say, oh yeah, I can do it. But there may be a few people, if you really say like the work of this committee is not the one day, but it's the other 20 days in the month.
Right.
Because it's a heavy lift. And I think that, the level of the members in terms of your career where you are, you don't necessarily have a lot of bandwidth. So I think that being part of the understanding will be important. And then I think probably the committee trying to maybe say public members, maybe some of the things you think will be helpful for the committee, because the description is very broad, like, oh, public member, and you bring some diversity, but like, what does that actually mean in terms of the kind of work that needs to be done on the committee? So that would be, and I don't think it needs to be so prescriptive, but I think the committee just knowing generally, what lines of sight and type of experience might be brought. So those would be my things to consider.
Yeah, those are good points, because the public member members do have a unique role stepping outside of the lawyer brain and speak that we all are involved with, and saying, how does this relate to the other goals, access to justice, other public goals, and non-lawyer thinking, basically. So very helpful. Okay, there's a bit of time, but everybody can think of the people that they might be interested in approaching. I do think the capacity to do work, obviously, is an important one, as Raquel noted, and the obvious implication she's making is that it directly impacts our ability to get work done. when people have time to do it outside of the meetings. And we're not doing like a lot of revising in real time in these meetings because this is done off the meeting time. So it's the other days when the actual work gets done. Okay, anything else on membership?
I just wanted to address that it will be Cassidy who's terming off as the advisor. So that's one of the attorney positions that we will need to fill. And then Carrie, you took over for Dan's original term, and so your term also ends this fall. And then Raquel, I believe it was already mentioned that you're also terming off this fall. So those are the positions that we are looking to fill. And please correct me if I'm wrong, but I'm not sure that we have anyone on our committee that has a family law background, family law practice. So that may be something we want to consider. And also, I'm not sure if we have any public interest attorneys on the committee currently. So that might also be a role that we might want to look out for in terms of applicants.
Yeah, very good points. Okay. March 31st is the deadline to apply, and letters of interest for leadership. Feel free to get in touch. I'll tell you all about it. Okay. The next item is legislative advocacy. Rachel.
Yes. So Karen sent out the link for SB 574, which really is like the big AI bill that is currently pending in the California legislature that would add a number of affirmative duties. Attorneys would be required to cite check every single citation that is in anything that's being submitted to a court, including AI generated citations. It specifically deals with issues of confidentiality, and it would create several affirmative duties that attorneys would be obligated to comply with. And that is a proposed change to the Business and Professions Code. So you can take a look at that link that Karen sent out. And then the Chatbot Act, I think, really kind of gets into some of the issues that the AI working group was talking about. Just in terms of some of the crossover, an example of, how 8.4 and 1.1.2 kind of intersect. I don't think it necessarily impacts the AI working group or COPRAC per se, but it is a bill that the state bar is tracking. Both of those are. So if anyone has any comments, any feedback, anything that you would like me to take back to Donna, who is our kind of legislative liaison, please reach out, send me an email, let me know so that I can get her that information and she can collate it and take it into account when she is working with the board on the legislative advocacy piece of things. But that is it from me.
Okay. Emil.
I guess it's not specifically to this SB 574, but I noticed that this was proposed by Senator Umberg. And my only thought would be, I don't know if would be helpful for maybe people from COPRAC to have a conversation with his office or the bar. I assume has already had conversations because he was also the author of SB 37, right? And so he's doing a lot he's obviously a lawyer. His colleague works in the malpractice space as well, but it might just be helpful for him to, talk to whether it's the bar, COPRAC, as he develops some of these things. Because I guess my take on this initially might be like, hey, we already have Rule 11 obligations. We already have similar obligations. Does this change really do anything? And so again, I haven't developed that thought, but that's just like my initial thought. Might just be helpful to see where this is all coming from.
for whatever it's for whatever it's worth, when I was at OCTC, I met with his office as part of some of the efforts with the fee bill, back when that was affecting state bar employees. And he was very pleasant and easy to meet with and chat with, and very receptive to conversations. So I would definitely support that.
One note about any type of contact, it's just to make it clear, because we all have clients and constituencies, that you're meeting with this person in what capacity, specifically. It's a different scenario if you are meeting with somebody on behalf of a client, and if you don't specify it, it might be unclear.
Yes, and COPRAC cannot engage in any legislative advocacy as a group unless it's authorized by the board. So I can let Donna know that the result of this conversation and kind of some of the suggestions, and let her know kind of what COPRAC's thoughts are. So yes, please reach out if anything comes to mind that you would like me to pass on.
Okay, thank you. The final item for the agenda is new business and the opportunity to agendize it, if that's a word. Let's agendize.
It's a word now.
Sorry, I think I'm the one that always has something to say for this.
The agendizer is what
Yeah.
you're.
All right, so I have three questions. So one, you were talking, Rachel, about OGC. I'm not asking, but I'm saying, is it something worthwhile for us to have a closed session where OGC talks to us about things that, like, comments that they have about what we're doing? Because it sounds like they have had some comments about, like, support that we maybe didn't have in certain things, or how we do things. As agency counsel, would they be interested in talking to us in a closed session? That's one. Second, we have a commenter that comes and submits comments very frequently. I think it's about his father and the DA in Sacramento, Mr. On, I believe. And so I looked at the Bagley-Keene guide, and it basically said that if something's not in our purview, we can actually tell them that they cannot comment on it. And it sounds like we've already instructed him kind of informally change those guidelines. But I know there's obviously risk if we incorrectly tell somebody not to comment, but is there a limit? I mean, it's not disturbing me in any way, but it just, it's not helpful to him. It's not helpful for us. Maybe his voice could be used elsewhere. So is there an opportunity for us to suggest that? And then finally, my third comment was for SB 37. Could we consider a ethics alert for that?
Yeah, I would say for SB 37, bring it. I do think it's important, and I do think that we should. A lot of us have done this in our own practices, but I think if you wanted to come to the next meeting and sort of suggest this is why it's important, this is why we should, that would be very helpful.
Okay.
Aaron.
I just was going to echo exactly that, because there are so many people petrified of this potential new cause of action for advertising and LRS violations, et cetera, et cetera.
Yeah.
So this would be an alert that, should be timely right now.
Yeah.
Yeah.
It shouldn't take too long, but I mean, honestly, I think it will be very beneficial to practitioners.
Yeah.
And interestingly enough, that comment that Rachel put on, or Karen put on the screen, that had to do with EAPs and referrals. The first thing that came to my mind on that was, how is this going to work under SB 37, right? Is it going to be considered an LRS, or, so yeah, I think it's, yeah.
There's a lot of activity around it, but a lot of questions even about just the basics, which I think an alert would help a lot of practitioners with.
I'm happy to work with you on that email.
Okay, great. Yeah.
Okay, great. Okay. Any other new business?
Well, I guess the other two questions were still pending. I guess maybe that was more of a question to Rachel. If you can speak to that today, and if you can't, that's fine.
Yeah, I will talk to OGC about the first question. The second question, yes. So we do have public commenters that attend basically any public meeting and provide comments. We do have commenters that will attend, all the committee meetings, the Board of Trustees meetings. That provision is in Bagley-Keene. However, I have never seen the board exercise their discretion to stop a comment unless it becomes like a physically dangerous situation. And I think that when I was reviewing the state bar's policy regarding public comment, it is open, it is welcome, and I have reached out to communications about this and asking if there are things that we can do to help address misguided comments, because I totally get that it is frustrating for people when they keep coming and commenting and then nothing's happening because they aren't in the right forum. So that's why we added in some of that language regarding what COPRAC does and the type of things that we can act on. But beyond that, I have reached out, I've sought guidance on that, and I don't think there's really too much more we can do on that particular issue.
The preface comments have helped, because there was certainly a period when we had many more public comments like this that were taking up a lot of time. Eleanor.
Can we add to the preface a direction where people can find the appropriate forum? Like,
Yeah. Well, I mean, it'd be like just call the state bar, because
if you have a question about the appropriate forum, you can call this number and they'll help you,
Yeah.
determine which meetings or which venues are appropriate for your concerns.
Yeah. What happens when you call the main line at the State Bar of California?
It's a very long wait.
I was going to say still no.
Actually, get directed to an online form that you can
There is an
submit.
online form. That's right.
And according to my clients, they've waited more than 3 months to get a response back.
So, I mean, I'm happy to add. I think we could add to the public comments that I would direct them probably just to the website to try to determine which appropriate office, because I don't want to get into it trying to figure that out for them. We can't say.
Oh, I
Yeah.
agree.
Because it's going to be dependent upon their issue as well. I mean, the public trust liaison has their phone number for members of the public. So that may be an option.
That's probably a good first stop.
To it.
Carrie.
Yeah, I was just gonna say maybe we could update our webpage where like our roster is with some other agencies where people like a link for DCBA's intake form, a link for intakes, OCTC's intake form, information about the public liaison, and like maybe we could even put like our preamble on there, and then give them a list of resources of other agencies that do investigate the types of complaints that they have.
I think that would be a good idea on the website even, yeah.
Rachel, is that something we could find out if we could put something like that together?
Yeah, I can take a look into that. And when Karen and I were updating the COPRAC website in anticipation of the appointment cycle opening, when I was looking at it, I realized that I think it could use a little jazzing up. There's not a lot of information there. And so I was planning on actually agendizing the COPRAC website for our next meeting. So that's perfect timing. So yes, I think we can discuss that and look into it.
I mean, obviously what we want to avoid is somebody coming here thinking they're in the right forum and then not being in the right forum and somehow missing their opportunity to bring a claim or something.
Yeah.
and other things. But I do think that the introductory statement has helped.
Yeah.
Because the name of the committee does sound like, we would be doing discipline, but we're not.
If we're permitted to tell them to stop them, are we permitted to tell them that it's not the right form? I appreciate there's some risk, but to echo Emil's earlier comment, I think it might be helpful to them if we can say, thank you.
Yeah, I mean, so there's some categories where if you go to every single committee meeting, I don't know that you're looking for nuance.
That's fair. They may be frustrated though and not know what the resources are. I mean, I'm just concerned about getting people the right resources so they can figure out where to belong,
I do think it would be helpful to be able to point them to an entry point for the state bar so that if they had something that was most definitely not us, they could find somebody who, like the public trust liaison, who could direct them.
I guess my question is, can we respond to them and tell? We can say it in the beginning, but should we also respond to any of the comments?
I have done that. I think I did that a couple of times and repeated the sort of line after, just to sort of reiterate it, almost as a response. And maybe we should just
call
do
so and so.
Okay. Yeah. But it's at least knock on wood for now, it has been just reduced. So I think that's helpful. Okay. Emil, you got your questions answered correctly and to your satisfaction? Okay. Any other new business? Anything else, Rachel, staff, anybody?
No.
Okay. Thank you. We're adjourned.
Thank you.
Thank you.
Have a
Hey,
good weekend.
everyone.
Thank you.
Thanks.
Have a good weekend.
Too.